Hello, everyone.
Hello.
Hello.
Hello,
Hello,
Marita.
everyone. Hello, Mrs. Stan. Hello. Hello.
Hello, I think. Thank you. Ms. Berkland, Mr. Friedman, Ms. Popova,
and afternoon.
and our interpreters, court reporters, Dawn, Mr. Gijon, Ms. Flavov, Mr. Hamilton. Good morning to you. Dr. Llano, ¿qué tal por México?
Buenas tardes.
Mr. Ril, Dr. Recena. Marisa, is everyone now on board or?
Let me see. I believe so. We also have the representatives of the non-disputing party connected.
Very good. And we have Ambassador De Cela with us. I cannot see him, but there are so many people.
Yes, let me check.
That it is difficult to know if. Very good.
I don't think there is the Embassy of Peru is connected.
Very good. So we can start.
I believe so.
Very good. Good morning to you. This is the final hearing in the UNCT case number 18-2, UNCITRAL, Gramercy Funds Management, LLC and Gramercy Peru Holdings, LLC against the Republic of Peru. On behalf of the Tribunal, I welcome you all, the claimants, the respondents, the court reporters, the interpreters, and of course, also the representatives of the non-disputing party. Before we start, I think our secretary will give some explanations regarding confidentiality, because as you know, this hearing will then be put on the website of UNCT and will be publicly available, but we have special procedures in place should there be confidential information. Marisa, could I kindly ask you to explain and remind the parties exactly how it works?
Yes, thank you, Mr. President. In accordance with paragraph 33 of procedural order number 12, the parties may orally alert the tribunal each time they intend to refer to protected information and request that that part of the hearing be held in private. Following such a request, I will be placing the representatives of the non-disputing party in the waiting room, and I will let the parties and the tribunal know when that exercise has been completed. The representatives of the non-disputing party will remain in the waiting room until the confidential section of the presentation is over. Then they will be placed back into the hearing room.
Excellent. Mr. Friedman, can I kindly ask you if you know whether we will today, since today you will be the leading figure in the presentation, whether there will you be invoking confidentiality at any time?
Our plan is not to. We've crafted today's arguments to try to avoid that circumstance arising. So I could see it arising only if there's a question from the tribunal that takes us into some of that evidence.
Excellent, excellent. So we will also try to formulate our questions in a way that we don't trigger these complications. Very good. Is there anything else regarding? Yes, I know. And that goes now basically for you, Mr. Friedman. Could you please speak slowly? You are being interpreted into Spanish. There are 2 court reporters pending on your very word, and we have time. So do speak slowly, and because otherwise it becomes very, very difficult for our court reporter and the interpreters.
Yes, thank you for that, Mr. President. If at any time I or anybody else is speaking too quickly, just give us a heads up and we will slow down.
Yes, and can the interpreters and the court reporters are welcome to just shout in whenever they lose track of what is happening, because it is fundamental. Don't be shy. It is fundamental that we have a good transcript in both languages, and it is fundamental that we do things slowly. So don't be shy. If you need, just shout in. I had it recently in another hearing, and yes, I think it is the proper way. Very good. Marisa, is there any, from the point of view of the Secretariat, is there any other issue you would like to raise before I give the floor to the parties?
Thank you, Mr. President. The interpreters have asked if the claimants could circulate only to the interpreters and the court reporters the speaking points of today's presentation.
We have done so.
Okay, thank you so much. Also, just checking that everyone is able to access the transcript in Spanish and in English.
We are receiving it on claimant's end.
Thank you, Mr. Friedman.
Mr. Hamilton, are you also satisfied with the that you are getting the transcript?
Thank you very much, Mr. President. Peru has access to the English and Spanish language transcripts. And good morning and good afternoon to all the members of the tribunal.
Very good. So now let me, if we were in a room, which would of course be much nicer, and I would have very much preferred, I would now give the floor to Mr. Friedman and then to Mr. Hamilton to present who is in the room. Mr. Friedman, are you still able to do that? Or do you want us, or would you prefer that the secretary just calls the roll?
We're in your hands. I do have a list of the participants that I understand are currently on today's meeting. I could read that if you'd like.
Yeah, why don't you do that? And we then ask Mr. Hamilton to do the same.
There's myself, Mark Friedman, my colleagues Ina Popova, Carl Reel, Glorianne Laveau, Berglind Birkland, Guillerme Resena Costa, Sarah Lee, Duncan Picard, Julio Rivera Rios, Mary Grace McAvoy, Eric Turkman. Those are all from Debevoise and Plimpton. From Estudio Rodrigo, Francisco Cardenas Pantoja. Also from Gramercy, James Taylor, Rob Lanava, Josh O'Melia, and Nick Paolazzi. I don't know if I've missed out anybody. If I did, I would invite them to add their name, but I believe that's who's attending right now from the claimant's side.
Very good. Mr. Hamilton, do you keep a track record of who is attending on your side, or do you prefer that the secretary calls the roll?
Thank you, Mr. President. I'll be glad to introduce the team of the Republic of Peru. I'm Jonathan Hamilton of White & Case, and it's my pleasure to introduce various representatives of the Republic of Peru who are connected. They are from the Embassy of Peru, the Ministry of Foreign Affairs of Peru, and the Ministry of Economy and Finance of Peru, as well as representatives of the Special Commission for the Defense of the Peruvian State. The representatives of Peru include Ambassador Hugo de Zela, Minister Giovanna Zanelli, Alberto Hart, Oliver Valencia, Ricardo Ampuero, Monica Guerrero, and Shane Martinez. In addition, we are joined by Mr. Bruno Marchese of Estudio Rubio in Lima, and by the following colleagues from White & Case: Andrea Miniker in London, Rafael Llano in Mexico City, Francisco Gijon in Washington, D.C., and the following additional colleagues in Washington, D.C.: Jonathan Ulrich, John Delabro, Sandra Huerta, Sofia Castillero, Antonio Nitoli, and myself. Thank you very much, Mr. President and members of the Tribunal.
Thank you, Mr. Hamilton. And we have from the U.S. Department of State, Marisa, we have some colleagues from the U.S. Department of State. Do you know who is attending?
Thank you, Mr. President. I see Ms. Nicole Sorton from the U.S. Department of State, Ms. Margaret Sedgwick from the U.S. Department of State, Ms. Amanda Blunt from the U.S. Department of State, Mr. Edward Rivera from the U.S. Department of Commerce, Mr. John Daly from the U.S. Department of State. I believe that's it at this moment.
Very good. And we have then our court reporters, Mr. Dante Rinaldi, Mr. David Kasdan, Ms. Dawn Larson, and we have the interpreters, Ms. Silvia Coya, Mr. Daniel Giglio, and Mr. Charles Roberts. Thank you very much for helping us today. So, is there any point of order before we can give the floor to Mr. Friedman for his conclusions? Mr. Friedman, is there any other issue? And this is not an encouragement for you to bring up any issue. Is there any issue which you would like to put on the table before we start?
I'm very pleased to report to you that there are no issues that we need to bring to your attention at this time.
Very good. Mr. Hamilton, what about you?
Thank you very much, Mr. President. The Republic of Peru wishes to welcome the representatives of the non-disputing party, the United States of America, and hopes and anticipates that we will have a rules-based proceeding, one that actually follows the rules. Thank you very much.
As we have had throughout all our hearings, Mr. Hamilton, I hope you agree with that. Very good. So, Mr. Friedman, give us an overview of how long your presentation will take, and then let's speak about breaks.
Yes, I think we will take close to the allotted time. We hope to be just a little bit under it, but and we have planned a break partway through. Once I give the roadmap within the framework of the speech that we have, I will indicate to you when we expect to take a break. I would expect that to be after about 90 minutes. If that's acceptable to the tribunal, we will obviously, we're in your hands. So
no. There are 2 points. First of all, this is more tiring than being in a room for everyone, and of course, especially also for interpreters and court reporters. So we said maximum 150 minutes with a 15-minute break. So whenever you feel that it is an appropriate moment to make a break, you make a break. If you even feel that you would like to make a second break, that's perfectly acceptable, and I leave it in your hands.
And Mr. President, if the tribunal would prefer for us to have 2 breaks, we could certainly structure it that way. But we really are, I completely agree with you. This is more difficult than being in person in many ways. And we want to make sure that everybody is comfortable and attentive. So why don't we proceed as we had planned? But if at any point you wish to indicate that we should take a pause a little bit earlier than we'd anticipated, please just let us know. And of course, we'll do that.
Very good. Very good. And you have made a presentation, which I think Ms. Berkland has sent to us, and we must give it a numbering, and that would be H. Who knows? Who is faster? Marisa, which H number do we have? Or do we have to look up?
Let me see.
We'll say it in the break.
Yes.
In the break, we will tell you exactly what.
H21, I think.
H21. Very good.
Let's check. Yes, thank you.
H21. Very good. Mr. Friedman, you have the floor.
Thank you very much, Mr. President. It's very good to see you. Also you, Madam Stern and Mr. Dreimer. On behalf of Gramercy and our entire Debevoise team, we must start by expressing our gratitude to all of you for your attentive, professional, and responsive conduct of this arbitration. And we also want to express our gratitude for giving us the opportunity today to engage with you on oral closing submissions, and your fortitude in doing so and making this work despite the global pandemic that has, of course, reshaped our world since the last time we were all together in February, right before all of this lockdown hit. And it seemed that this virus was something on the distant horizon. Gramercy
It is amazing, Mr. Friedman, how the world has changed since we last met. It is a really surprising development. Yes,
it is.
And
I
shows the
remember,
fragility of many things we take for granted.
It does. And I remember the sort of anxious conversations that we had outside the hearing room about what was happening. And I don't think any of us really could have anticipated we'd be in something this widespread, this deep, this sort of affecting everybody in such the way that it is. So we really do appreciate everybody in the international arbitration community and you kind of getting on with business and making it possible to continue to progress cases. For this case, as you know, Gramercy has always considered it regrettable that Peru's obstinate and unlawful conduct has made this arbitration necessary at all. Gramercy invested in Peruvian bonds because it believed in Peru. It believed in Peru's renaissance. It admired how responsibly Peru had worked with its creditors to resolve all other legacy debt, pull its economy out of the abyss, rejoin the international financial community, and attract foreign capital like Gramercy's to return to the country. Now, Gramercy understood that receiving payment on the bonds would likely take time and effort. It might require consensus building and compromise, and perhaps even assertion of legal rights associated with the bonds. But as you heard from Mr. Königsberger, Gramercy always expected that Peru would ultimately pay this indisputable sovereign obligation as Peru's constitution and law required. And Peru has had countless opportunities over the year to do so. Gramercy itself repeatedly proposed to discuss a consensual arrangement that could have benefited everyone, the bondholders and the state alike. Even after the Constitutional Tribunal issued its order in 2013, but before the ministry promulgated the value-destroying formulas that we will look at again later, Mr. Königsberger wrote to Peru requesting collaboration in the search for a solution to the problem posed by the land reform bonds and offering to help broker a deal that would, in his words, benefit all parties involved and resolve the debt while also, in his words, mitigating the impact of Peru's immediate budgetary priorities, and that's CE 185. But Peru instead chose a different path. It took measures to wipe out Gramercy's investment in Peruvian sovereign bonds through unlawful means, including an arbitrary and irrational bondholder process. And so instead of fairly resolving the debt, Peru breached the US-Peru Trade Promotion Agreement. In our time with you today, we'll proceed as follows. I will first summarize the evidence and arguments proving that Gramercy had a clear legal entitlement to be paid current value plus interest on the bonds, and that Peru breached the treaty by refusing to do so and extinguishing the debt instead. Mr. Rosena Costa and Ms. Laveau will contribute to that argument. And I think, Mr. President, after that segment, we propose to take a break. Mr. Reel will then explain why Gramercy should be compensated based on the intrinsic value of Gramercy's land bonds. That requires a payment of a sum of at least $840 million as of May 2018, which of course will be greater now because of the continued accumulation of interest since that time. Ms. Popova and Ms. Birkeland will then show why Peru's jurisdictional objections all fail, and I will offer a few brief closing words. Because our time is limited, and we want to speak slowly and at a comprehensible rate for the tribunal, we will not today address every point we presented in our written submissions. That does not mean that we abandon those points. We do not. It simply means that we are trying to focus today on certain issues that we think will be most important to you. We of course invite your questions. We are here for you to make your job easier. So if something is on your mind, please give us the opportunity to address it, and we will. So I begin by establishing Gramercy's entitlement. And it's clear that Gramercy had a valuable asset when it bought Peruvian land bonds. In fact, if there's a single central issue in this case, it's this, that Gramercy's land bonds were highly valuable sovereign obligations and not just worthless, old, and even, as Peru has put it, smelly pieces of paper. That is the central issue because it is at the heart of both parties' respective arguments. Peru's primary defense is that Gramercy really has nothing to complain about. Whatever crumbs the ministry offered it are better than nothing. According to Peru, notwithstanding the Constitutional Tribunal's 2001 landmark decision, the land bonds were worthless when Gramercy bought them. Peru's valuation experts similarly assumed that the debt had no value other than its denuded face value, such that offering anything more than 20 cents for Gramercy's bond, 20 cents, was a hair extension for which bondholders should basically say thank you and stop complaining. But if Gramercy is right on this point, and the bonds actually had significant value, then Peru has really no defense. It is practically self-evident that the bondholder process is expropriatory and unlawful, that it imposed a massive haircut, and that it simply is an elaborate mechanism for the state to extinguish its significant obligation for a pittance. Now, on this central issue, we submit to you Gramercy is right, overwhelmingly, and Peru simply continues to fight a battle that the MEF lost nearly 2 decades ago. You've seen the evidence and heard now from both parties' experts, and all of that shows that from 2001 at the latest, Peruvian law was clear. The land bonds were not worthless as they would have been at their nominal or face value. To the contrary, Peru's Constitutional Tribunal held in 2001 that Peru could not pay the land bonds at nominal value. It had to pay them at current value. It stated, despite the fact that using the bonds as a means of payment was not unconstitutional, the payment system to which said procedure was subject was and continues to be unconstitutional. So there should be no doubt that the land bonds are debts of value that under Peru's constitution must be paid at their current value. Justice Reveredo, who was a member of this Constitutional Tribunal in 2001, told you that. And so did Professor Mario Castillo, Peru's foremost expert on the law of obligations, who even respondents' expert had cited as authoritative. And while respondents' expert, Dr. Hans Kopf, had initially said something else in his report, on cross-examination, he agreed that the land bonds are obligations of value under the Peruvian Constitution and the Civil Code, and that the Constitutional Tribunal was correct to hold that they were. So when Peru tells you, even in its post-hearing brief, that the land bonds are examples of debt to pay money rather than debts of value, it does so not only without the support of its own legal expert, but in contradiction to that expert's own testimony on the stand. Moreover, and this is very important, this current value requirement was not empty and meaningless, as Peru's arguments all imply. Peru basically says, okay, maybe we had to pay current value, but it didn't really mean anything. You couldn't attach any significance to it. It means only what the Constitutional Tribunal in 2013 and the MEF then in its Supreme decrees said it means. That was simply wrong. The idea of current value, the principle of it, was and remains a well-established principle, rich with content. Its basic idea is so straightforward that even Minister Castilla acknowledged that it means restoring the amount's original purchasing power. That's the principle. And that's not abstract, or there may be questions about means of doing so, but it's not an empty concept. Now, in addition to preserving the purchasing power of the land bonds principle, the legal obligation to pay compensatory interest on those amounts is equally straightforward and uncontroversial in Peruvian law as it existed prior to the time Gramercy invested. Again, as Dr. Hans Kopf acknowledged, the 2004 Constitutional Tribunal decision confirmed that the bondholders had a right to payment of the updated debt plus interest. As I will discuss at greater length also in a few minutes, the Constitutional Tribunal, again in 2013 and 2015, and the Supreme Court in multiple decisions since 2013 have likewise confirmed that the entitlement to interest exists as well as and on top of the updating. Consequently, there can be no serious dispute if you take seriously what Peruvian law was about the two core components of Gramercy's legal entitlement: an updated principal amount that restores the bond's original purchasing power, plus compensation for time value of money in the form of interest. Current value plus interest. That's what Peru's constitution and law plainly required, and what Gramercy correctly understood and legitimately expected at the time of its investment. Moreover, it was also evident what that entitlement meant in practical terms. Again, not some abstract fluid concept that can mean anything. When bondholders went to court to enforce their land bonds, the courts of Peru regularly updated the principal using CPI, the Consumer Price Index, and then added interest. Over a decade-long period following the 2001 Constitutional Tribunal decision, the law was in fact so clear that in 2011, the Peruvian Congress, in a formal report, recognized a, quote, uniform jurisprudence in this area. As Vice Minister Sotelo confirmed, bondholders routinely obtained court judgments against Peru reflecting precisely that uniform jurisprudence. And you know what? It's no surprise that the courts followed this approach. As Professor Castillo explained, there must be a logical correspondence between what we update and how we update it. If you're trying to establish the current value of a quantity of gold whose value must be restored, you of course would look at the price of gold and gold indexes. Of course, it's the right thing. You wouldn't look at the price of cattle. It doesn't make any sense. But if you need to measure inflation, which is the thing that had to be erased and updated for, well, then you use an inflation index, which is, of course, an index that is regularly published and maintained by Peru's own authorities, and it's called the Consumer Price Index, the CPI, as both Professor Castillo and Justice Reverado explained. So while CPI is not the only way of applying the current value in the abstract, it wouldn't be the right way of applying the current value, finding the current value of a quantity of gold. It is the only conceptually correct way of applying it to the land bonds. And so the value of the land bonds at current value is legitimately the value of CPI updating. Now, Peru, nevertheless, despite the evidence even of its own expert in these proceedings, nevertheless contends that the whole situation was plagued by massive uncertainty lasting over a decade, and that therefore Gramercy's rights or the rights of any other bondholder were basically meaningless. Now, in general, you know that argument must be wrong. I mean, as we just saw, Peru's own courts were able to apply the law consistently without drowning in this alleged sea of uncertainty. They didn't have problems figuring it out. But Peru's argument is also wrong in each of its particulars. None of the arguments establishes any genuine uncertainty over Gramercy's fundamental rights or expectations. So let's look at those arguments Peru makes on this point. First, Peru says that some courts in Peru apply different CPIs, such as regional CPIs or the central bank automatic adjustment index. But as Professor Castillo explained, all of these indices are CPIs, including the central bank index, which is simply Lima CPI measured in 1 month's delay. In contrast, Peru has not adduced a single example, not a single example, of Peruvian courts applying a method other than CPI to the land bonds before 2013, not a single example. And they would have been party to every case involving the land bonds. Its expert resisted giving a straight answer initially, but eventually accepted that he wasn't aware of any such decisions before 2013. And Peru's disingenuous claim that some courts had applied dollarization was short-lived because you will recall, Mr. President, that on questions from the Tribunal, counsel for Peru had to concede that none of those cases that Peru invoked involved the land bonds. Moreover, there was also no uncertainty caused by the so-called adjusted CPI. That was an index that the Ministry of Economy and Finance made up at some point along the way that was never applied by anybody, never used in court, and which Professor Castillo rightly called out as a, quote, cheeky attempt to skip over hyperinflation to simply reduce the debt. It was just a made-up way of getting rid of the debt. So there was no uncertainty at the time, none, that at least if you went to court, the current value of the land bonds meant their CPI adjusted value. Second, Peru says that courts apply different interest rates. In fact, the courts routinely affirmed bondholders' right to interest at the stated coupon rates at least, and they did so in many, many, many cases overwhelmingly. Now, Peru's quantum experts conceded that in the few cases that were exceptions to that, when courts on occasion departed from the face rate of the coupons, they did so to award higher, not lower interest amounts. The Saavedra court, for instance, awarded interest at a legal rate that was as high as 300% at some points, which resulted in an interest award 20 times greater than the principal. And the Luna judgment awarded additional default interest of almost 4% on top of compensatory interest at the 4%, 5%, 6% coupon rates. So there was also no uncertainty about interest, at least at the stated coupon rates, none. Third, Peru points to various legislative bills that did not become law. And I want to comment on this. As Gramercy previously showed, with the exception of one loan bill that never went anywhere and the MEF's own efforts, the reports and bills that Congress actually passed and studied carefully actually converged on CPI updating. They all had CPI updating in them, and they provided, if anything, further evidence supporting CPI updating plus interest. But that's not the main point, because even putting that fact completely aside, even if the bills had been much more diverse and had methods like the price of cattle as the updating method, it wouldn't have mattered, because these bills just don't support Peru's uncertainty claim in this arbitration. All they show is that Peru did not succeed in creating an administrative payment scheme that could have provided an alternative to enforcing legal rights in court. So at most, they would show that there was uncertainty about whether Peru would create such an administrative scheme. That in no way diminishes the certainty of the constitutional and legal rights Gramercy had and that it could enforce in the court system. As Mr. Königsberger told you, Gramercy had always expected. And that is also why Vice Minister Sotelo had to concede that despite the failure of the legislative and executive branches to enact a land bond payment scheme, bondholders always had the right, and this was the existing legal framework in Peru as she conceded, bondholders always had the right to vindicate CPI-based current value plus interest in court. So the fact that none of the bills became law also does not establish any uncertainty about Gramercy's legal entitlement to CPI updating plus interest. Yes. May I pause for just a moment, Mr. President, and just point out, yes, there we are. Madam Stern, I'm sorry, the camera had fallen down and was looking at your notes, which we saw you were diligently taking, but we'd rather see your face. I briefly also just want to mention one other minor point, I think, which Peru apparently has abandoned. That is its misguided reliance on the Constitutional Tribunal's 2004 decision on, that's the one that endorsed a voluntary dollarization scheme. You remember that on cross-examination, Dr. Hunskoff, who initially had put much emphasis on that, admitted that after finally reading the decision in depth, which I guess he hadn't done before he wrote his report, he had realized that it had an important qualification, namely that the tribunal's holding was that the emergency decree's dollarization proposal was constitutional because it was a, quote, voluntary option, just as Gramercy and its experts had said all along. So this voluntary option about another proposal in no way, again, creates uncertainty about Gramercy's legal entitlement. And consequently, and that's it, those are Peru's arguments on this point. And if you really read through them, what you see is the following, that there was no existential uncertainty as Peru contends. And Gramercy's investment in the land bonds, therefore, was not just some gamble or an option, as Peru now misleadingly attempts to characterize it. In fact, Peru's expert, Dr. Hunskoff, to whom the gamble and option quotes trace back, actually walked back that testimony on the stand. In his own words, he conceded that that was not the most accurate way of characterizing it. He admitted that there could in fact be no doubt about Peru's obligation to pay the land bonds, and that at least after the 2001 decision, any bondholder had a clear right to payment at current value. Therefore, while Gramercy could not be certain about whether it would succeed in helping forge the win-win global consensual restructuring that it envisioned, it was right to be highly certain that either by some kind of negotiation or legislation, or if necessary, litigation in Peruvian court, it would ultimately be paid current value, and that this value could be determined by using CPI and adding interest. Now, having addressed you on Gramercy's legal entitlement, we now turn to Peru's breaches of the treaty. Peru's campaign to wipe out Gramercy's land bonds for a tiny fraction of their true current value violates 4 of the treaty's substantive protections. First, it violates Article 10.7 through its unlawful expropriation. Second, it violates Article 10.5 by failing to accord Gramercy the minimum standard of treatment under international law. Third, it violates Article 10.4, the most favored nation obligation, by depriving Gramercy of effective means to assert claims and enforce rights. And finally, it violated Article 10.3 by according Gramercy treatment less favorable than the treatment Peru accorded to Peruvian nationals. Now, I want to discuss each of those in turn. First, Peru has expropriated Gramercy's investment. It's worth just refreshing ourselves on what the treaty actually says, because Peru's arguments are sort of penumbral extensions of it. Article 10.7 is pretty clear. It prohibits expropriation, either direct or indirect, except when carried out for a public purpose in a non-discriminatory manner with prompt, adequate, and effective compensation, and in accordance with due process of law. And then Annex 10B, which the parties have focused on, identifies 3 factors relevant to what is clearly a fact-specific analysis of whether an indirect expropriation has occurred: economic impact, interference with distinct, reasonable investment-backed expectations, and the character of the government action. All 3 factors show that Peru expropriated Gramercy's investment. I want to start with the economic impact argument. Both parties for this agree with and rely on the Zayap Shum Tribunal's holding that a state can commit an indirect expropriation when its measures lead to a total or substantial deprivation of value. Total or substantial deprivation of value. Here, that sort of deprivation is a mathematical certainty under any iteration of the ministry's updating formulas, whether we look at the February 2014 formula or the August 2017 one. Now, the first one is pretty easy to establish. Peru's own quantum experts called the valuation in the first formula the minuscule, and they were right. It returns a valuation of a grand total of $861,000 for all of Gramercy's nearly 10,000 land bonds. That is about 0.1%, or less than the total value of those land bonds under any of the potential valuations that Mr. Reel will discuss later. Now let's pause for a moment, just to think about the implications of Peru's admission that its first formula yielded this minuscule valuation of about $861,000. But first, it must disprove Peru's contention that the bonds were worthless and the bondholder process somehow imparted value to the bonds. For if that were true, Peru could have simply stopped at the first formula, which would have provided the hair extension. It was a lot more than 20 cents. And if that's really the measure, then why bother to change it at all? But I think even Peru recognized that they could not get away with theft that brazen. Second, the minuscule valuation was the only offer that the government had made by the time Gramercy had to decide whether to exercise its treaty rights. That was the program in force. While Peru appeared to offer something like current value then in its February 2017 Supreme Decree, so much so that another Gramercy fund invested in additional land bonds, Peru then withdrew that offer and so it came off the table. And that brings us to the ministry's August 2017 formula. And that still results in a deprivation of value so substantial as to be expropriatory. The Zayap Shum Tribunal found Peru liable for expropriation when the challenged measures caused the investors' net sales to fall by an equivalent of 96%. And Peru's deprivation here is actually on the same order of magnitude. The $34 million that Peru claims Gramercy could have received through the bondholder process is less than 2% of the $1.8 billion of value that Professor Edwards showed, and a mere 4% of the $840 million of value that Mr. Reel will present later. Moreover, even taking Peru's case at its highest, $34 million is not and never was a real number. Peru never actually offered that amount to Gramercy. They never said, here, you can have $34 million. Instead, the quote unquote offer on the table was for Gramercy to commit to submitting all of its land bonds to the unproven and dilatory bondholder process, which we'll talk much more about later, in which, just to give some highlights, the ministry would have near total discretion in how and when to pay whatever it chose to award, and in which Gramercy was the last in line to receive payment. Gramercy would therefore have had to subject its investment to the whim of a government ministry that had shown great antipathy to bondholders generally and to Gramercy in particular, and had not abided by the requirements of Peruvian law in creating the process, and that was already on its third set of economically indefensible valuation formulas with no promise new ones wouldn't come later. And to take up that offer, Gramercy would have had to, at the outset, waive in advance all of its rights, including its rights under the treaty. So Peru's offer that Gramercy could submit to its process is not an offer of $34 million or any other amount of actual payment. Furthermore, since Gramercy has exercised its treaty rights, the fact is that Peru now offers no procedure through which Gramercy could receive any value on its land bonds, let alone current value. So the value on the table right now for Gramercy is actually zero, even less than the original minuscule valuation. As for the second factor of those Annex 10B factors, I already explained earlier, and it's in our papers, why Gramercy, at the time of making the investment, legitimately expected that Peru would eventually pay its land bonds at a value that reflected their original purchasing power plus interest. That was, after all, Peru's constitutional obligation, and I dealt with that in the legal entitlement section. Now, the third Annex 10B factor looks at the nature of the government action. When we get in a few moments to the minimum standard of treatment analysis, we will address at considerable length the arbitrary and unlawful character of the government's conduct in creating and implementing the bondholder process. So all of that is relevant to the expropriation analysis as well. For the moment, I simply want to show how mistaken Peru is to rely on the treaty's language about saying that for non-discriminatory actions designed to protect legitimate public welfare objectives such as public health, safety, and the environment, those will rarely be indirect expropriations. Now, on its face, that provision, of course, bars no claims. I think it acknowledges that even non-discriminatory measures to protect public health, safety, and the environment can in fact be expropriatory, depending on the particular facts and circumstances of a case. Moreover, as we'll show later, Peru's conduct did discriminate, it wasn't non-discriminatory, against Gramercy. Moreover, the objectives Peru invokes here are not like those public health, safety, and the environment type objectives. Peru itself characterizes the aim of the bondholder process as resolving a long-standing domestic dispute, promoting the general welfare, providing basic services, and ensuring fiscal balance and sustainability. Those are its characterizations of the purpose. None of those are obviously public health or safety measures. But even taken at face value, these fiscal objectives do not justify an expropriation. They're so general and broad that if accepted, they would entirely swallow the rule against expropriation, right? I mean, on Peru's view, a state could simply always state the self-evident conclusion that taking more money or value for the state will improve fiscal objectives of the state and ensure balance and fiscal balance and sustainability. But that obviously can't excuse a taking. Tribunals like Siemens versus Argentina and others have expressly rejected that kind of claim. Peru has effectively deprived Gramercy of all, or substantially all at least, of the value of the bonds through means that fall below the minimum standard, with the sole aim of not paying bondholders what Peru's constitution and law entitled them to receive. That is, under our treaty, more than enough to constitute an unlawful expropriation. So I now turn to the minimum standard of treatment. We have already explained in our briefs what the minimum standard of treatment requires, and I don't want to dwell on the legal arguments here. Suffice it to say, for today's purposes, the minimum standard of treatment is a flexible and open-textured standard that often depends on the facts of a particular case. And it includes conduct that is, among other things, arbitrary, grossly unfair, unjust, idiosyncratic, completely lacking candor and transparency, and that frustrates investor reliance on state representations. To quote Peru's expert, Professor Reisman, in his academic writings, the minimum standard of treatment is an evolving concept whose contents overlap if they have not become congruent with the fair and equitable treatment standard. And many tribunals, including Bywater and CMS, have observed that the content of the minimum standard of treatment is not materially different from the fair and equitable treatment standard. Hence, the minimum standard of treatment under our treaty also includes the quintessential elements of fair and equitable treatment, such as protection of legitimate expectations, consistency, transparency, and rationality in decision-making. Now, Peru's conduct fell below that minimum standard in at least the following 5 ways. First, the ministry improperly interfered with the Constitutional Tribunal's decision-making process. Second, the ministry, in purporting to implement the 2013 Constitutional Tribunal order, disregarded key provisions of that order. Third, the ministry adopted arbitrary and irrational valuation formulas in the Supreme decrees themselves, all of them. Fourth, the ministry issued the Supreme decrees in violation of Peru's own administrative law. And finally, the ministry's bondholder process is, in its operation, arbitrary, discriminatory, and a failure. So let me begin with the ministry's intervention in the Constitutional Tribunal's decision-making process. So first, let's consider this issue. And some basic facts about what happened in the July of 2013 are well established, and this set of facts, I believe, is undisputed. The Constitutional Tribunal had deliberated on this issue for about 2 years. In mid-July 2013, a 4-justice majority agreed on a decision confirming that the land bond should be updated in the totally conventional way that courts have been using, that is CPI plus interest. But then there were some last-minute ex parte meetings with high-ranking members of the executive. On the very day that the court was again meeting in plenary session to sign the CPI decision, 3 justices suddenly had a change of heart. A new opinion emerged, and 3 justices signed this hastily prepared new opinion with dollarization. Justice Messia, who was one of the original 4 justices, objected and invoked his right under the court's rules to have 48 hours to prepare a dissent. But the Chief Justice overrode that right, and he or someone else that day transformed the original majority opinion, which he hadn't written. Justice Eto had carriage of the issue until then, but transformed the original majority opinion into Justice Messia's opinion by using whiteout, by whiting out signatures and typing in, instead of "this is the decision of the court," saying "this is my dissent," which then enabled the chief to declare a 3-3 tie and to use his casting vote to ram through this new decision as the formal opinion of the tribunal over 3 dissents. That's an undisputed sequence of events. And it's shocking, if you just step back, I don't want to lose sight of how shocking it is. We are not aware of a responsible judicial system that would tolerate the use of whiteout to falsely create a dissent at the apex court of the country. And submit to you that that alone probably, once we know about the internal workings of it, is below the minimum standard of treatment. But There's much more than that too, because the situation, as we've discovered it through the arbitration, has turned out to be much more pernicious. For the evidence has also shown that this about face in these last days by 3 justices of the Constitutional Tribunal was the product of the ministry peddling false information to the Constitutional Tribunal. You will recall that in sworn testimony to Peru's Congress, Justice Edo, who was the person who had carriage of the issue for all of those years, he was the lead justice on this case, testified to having in those last days a historic meeting in the ministry during which the Minister of Economy himself told the justices that the debt, if updated using CPI plus interest, might reach the stratospheric amount of $18.5 billion. And Justice Edo explained that that fact moved the justices to change their opinion because they were concerned, obviously, about the impact of $18 billion on Peru's budget. Peru has denied that this kind of meeting happened, but we submit to you that the weight of the evidence shows that it did if you look at it objectively. And we submit the following 6 points for you to consider. First, there was no reason for Justice Edo to lie. This was not some casual story told to at a dinner party or even to a reporter in a newspaper. This was sworn testimony in Congress in the presence of the other justices. This is the last place where a justice of the country's highest court would make up some fantastical story. Second, Minister Castilla's hearing testimony about this episode was remarkably evasive. You'll recall that he kept insisting that he didn't have any official meetings with a plenary of the justices. He eventually and somewhat grudgingly acknowledged that he did meet, at the very least, with Chief Justice Urviola during those last fateful days, and that they probably discussed the land bonds as a topic. Third, Minister Castilla's contemporaneous statements to the media actually confirm that he had inside information about the outcome of the decision. During the long deliberation period, the minister was rigorous about taking a no comment position, as he did repeatedly in the press, and we showed you one of those during the cross-examination. Yet in those last few days, before the Constitutional Tribunal issued its decision, in the period of time in between the original majority opinion and the new opinion suddenly emerging, Minister Castilla was quoted in the press in language he didn't deny, suddenly stating that he was confident that the Constitutional Tribunal would reach a decision consistent with the constitutional concept of budgetary balance. Confident. And that, of course, is remarkable because it's exactly what the putative majority decision said it was doing. Just as Minister Castilla had been confident about, the justices premised their abandonment of the established legal framework of CPI plus interest on the need to balance the state's various budgetary obligations. That's the central idea animating the decision, and what Justice Edo told you made them change their mind. Think about this for a second. 5 days before the Constitutional Tribunal issued its decision, and after the original decision had already been written, Minister Castilla knew not only that the court was about to issue a decision, but he also said that he was confident about the specific principle upon which that decision would be premised. Fourth, the July 2013 order clearly indicates that the justices now understood that CPI plus interest would be so expensive as to threaten Peru's very fiscal stability. As the order itself says, any CPI calculation will suppose an amount that is unaffordable for the debtor and would generate severe impacts on the budget of the Republic to the point of making impracticable the very payment of the debt. So it was clear from what the tribunal wrote in its decision that it really was animated by some concern that paying the debt as it was really owed would somehow break the Bank of Peru and cause financial ruin. That really was on their minds, and you can see it in what they wrote. Fifth, the Constitutional Tribunal adopted an approach in its decision that include elements and a combination of elements that could only have come from the ministry. That's because there is a combination of elements that basically has the fingerprints of Professor Seminario's work. You'll recall he's the economist who the ministry hired back in 2001, and he prepared a report that was supposed to be part of a draft bill, but you'll recall Minister Castilla's testimony in his witness statement, which was that that bill never went anywhere and never made it outside the MEF. So this was just within the MEF at that point. We think about it today, but at that time, nobody had known about Professor Seminario's work. But let's look at compare what's in Seminario to what's in the Constitutional Tribunal decision. The first of these shared features is the erroneous belief that CPI is unreliable in times of hyperinflation. That idea was not unique, in fairness, to Professor Seminario. It had been in the intellectual history of this before, but it certainly was a major and driving feature of his analysis, just as it was for the Constitutional Tribunal. The next two elements, though, are a little bit more unique. The second shared feature was the use of a parity exchange rate. And it's striking that both the Constitutional Tribunal order and the Seminario report adopted precisely the same reasoning, that the official rate didn't express market value, parity exchange rate. The third shared feature was that the Constitutional Tribunal and the Seminario report both updated the value. Now they're updating value here, which is an inflation adjustment, but they did it using US Treasury bond yields. To the best of our knowledge, this unique combination of elements has no antecedent in the more than a decade of analysis and consideration on this issue. If it did not come from Professor Seminario's work, where did it come from? One way or another, whether directly or indirectly, it must have come from the ministry. And sixth, the ministry's interference was affirmed not only by Justice Edo, but also by his colleagues. Justice Urviola, for example, stated in the press that he met with Mr. Castilla and Prime Minister Jimenez in the days immediately leading up to the tribunal's decision. On cross, Minister Castilla said that he would not question that public statement. Similarly, Justice Alvarez in his testimony described in memorable terms how the justices basically threw up their hands at the end and ceded authority to the executive on this monetary point. He explained that the justices were unsure of the consequences of the various updating methods, and thus simply, in his words, withdrew and liquid paper was used. The weight of the evidence is clear, and Peru has no answer to most of those points and none to the combined weight of them. Instead, Peru's defenses purposely miss the point. First, they cite to select portions of Minister Castilla's testimony and of the congressional testimony as alleged evidence that the MEF didn't have these communications. But the testimony Peru cites really addresses an entirely different allegation that has been cause célèbre in Peru, which is that the ministry actually wrote the purported majority opinion. We're not submitting our case on that basis, but that's mostly what the testimony they cite in the post-hearing brief responds to. Second, Peru cites to the ministry's request for clarification after the 2013 CT order as alleged evidence that the MEF did not agree with the order. They might not have agreed with the order in all its respects. None of those challenged the valuation method, and both of those were efforts to either tell the Constitutional Tribunal, don't make us do anything at all, or give us a lot more time to do it. But none of them in any way undermine the story that we've just told you, that they provided false information to the court to make them move off of CPI plus interest as the basic rule. Finally, Peru claims that the Constitutional Tribunal confirmed the validity of the July 2013 resolution through subsequent resolutions later that year. But of course, by that later in that year, in the next few months, they would have no reason to believe that the information they'd been provided about the $18.5 billion figure was false. So of course, they would have continued in the same vein. In conclusion, this order came about because of false information that arose through unilateral last-minute intervention that bondholders had no chance to rebut. So far as we can tell, nobody ever came to the bondholders and said, hey, we've heard your method will cost $18.5 billion. What do you say to that? Nobody believed that. The order was promulgated hastily in contravention of the tribunal's own procedural rules and normal practices of apex courts. And it created a pretty important reversal of the existing legal framework about CPI plus interest, engineered through these misrepresentations and scare tactics. And we submit that if that's what you find the facts to be, that clearly falls below the minimum standard of treatment and is a breach of the treaty. I now move on to our second point, that the ministry didn't even comply with this 2013 order, and it didn't do so in two really important respects. First, the ministry did not follow the tribunal's balancing instruction. As we saw above, a central principle of the 2013 order was balancing competing imperatives. And Mr. Castilla conceded that the ministry had to carry out the implementation of that order in a manner that would ensure there would not be a serious sacrifice of either element of the balance, paying the bondholders or fiscal sustainability. So you would think that what the ministry should do, if Minister Castilla's testimony was accurate, and we think it was, that they had to follow that in implementing it, that they would have thought about what is this balance that the Constitutional Tribunal has directed us to do. They told us to use a method. We have discretion about how to carry it out. How do we do that? The MEF never did anything of the kind, and they didn't even try to. For his part, Minister Castilla admitted that he didn't read the order in detail, and he dismissed the 2014 Supreme Decree that established the bondholder process as one of many decrees that I would sign on a daily basis. Okay, he was the minister. Maybe he was busy. But that approach seems to have pervaded the whole ministry. Minister Castilla and Vice Minister Sotelo confirmed that the ministry did not engage in any balancing analysis at all. As the tribunal will recall, Peru has also adduced no evidence to the contrary. It presented no analyses purporting to assess how much bondholders would receive, how that amount compared to the true current value of the outstanding debt, or what the impact on Peru's fiscal budget would be under any version of its formula or any alternative method. Without doing any of that work, the ministry simply couldn't have implemented the 2013 order in the way that the Constitutional Tribunal intended, and importantly, the way that Minister Castilla acknowledged it was required to do. Now, that's a kind of qualitative approach about the work that they didn't do, but I want to now talk about a very important second failure to carry out the tribunal's order, and that has a very material and specific impact, identity. That is that the ministry failed to include payment of compensatory interest. As we saw before, the courts in Peru have always awarded bondholders compensatory interest in addition to principal updating. And the 2013 Constitutional Tribunal order itself reaffirmed that the ministry should do the same. It should update the principal to bring it to current value and add the interest, plus the interest, they said. A 2015 opinion of a CT justice that sort of referenced this 2013 order similarly observed that the tribunal had ordered the ministry to pay the full updated amount plus interest. And Peru's Supreme Court has confirmed that obligation to add interest on at least 5 occasions since the 2013 order, in 2015, 2016, 2017, and twice in 2018. And you will recall that Dr. Hunskopf himself submitted 4 of these decisions into the record with his rejoinder report, and a 5th one reaching the same conclusion is Exhibit CE 654. The tribunal will recall one of these cases in particular, Cassation Appeal number 1139-2016 from the year 2018, which the parties discussed at the hearing. In that case, the Supreme Court actually reversed the lower court's decision precisely for the failure to add interest. Dr. Hunskopf endorsed that case as an example of how Peruvian courts applied the 2013 Constitutional Tribunal order. He agreed that after updating with the method determined by the tribunal in July 2013, in addition to this, compensatory interest is added. He also accepted that the compensatory interest owed is the interest rate pre-established on the bond, which, as the Supreme Court made clear, applies on top of Treasury bond yield updating. In fact, Dr. Hunskopf stated that this judgment reflects the essence of the provisions of the resolution in 2013 by applying dollarization and clearly interest, he said. And he declared that the result is highly coherent under Peruvian law. Now, Peru has really no response to this evidence. It has even dodged the tribunal's direct question in Procedural Order 11 about the legal consequences of this Supreme Court decision. Peru devotes 1 sentence to the subject in its post-hearing brief. And here's what it says, because it really deserves some scrutiny. It says, while some local courts in Peru may have applied compensatory interest in this manner, the application of compensatory interest has been specifically rejected in other fora. This is a remarkably misleading and dismissive statement for such an important point. This is not some local court that we are talking about. This is the Peruvian Supreme Court, the highest court in the land on non-constitutional matters. And the other fora to which Peru refers is the feudal internal appeal process to the MEF itself in its own bondholder process. Neither Dr. Hunskoff nor Peru has brought you a single case from a court of Peru, at least after the Supreme Court decisions that held to the contrary. The legal situation is therefore clear and unequivocal. The law of the land in Peru is that what the Constitutional Tribunal meant in 2013 was what it said, and that the ministry was obligated to pay compensatory interest in addition to updating principal. Update the principal plus the interest. However, despite bondholders' clear entitlement to interest, the ministry never included it in its formulas. Not even with the last Supreme Decree of August 2017, which postdated 2 of the Supreme Court decisions. It's simply not in there. So the ministry just ignored the binding order of the Constitutional Tribunal and in 2017, clear legal precedent of the Supreme Court. And by doing so, it wrote off decades of interest, the single most important component of the compensation due to bondholders, given the fact that this debt has been unpaid for 40 or 50 years. And what's Peru's justification for this blatant omission? They initially seem to argue that, well, no, it's in there. Compensatory interest is accounted for because it is somehow built into the US Treasury bonds. But that is both legally and economically wrong. Legally, as we just saw, that's obviously not what either the Constitutional Tribunal or the Supreme Court understand. The Constitutional Tribunal said use US Treasuries to update plus interest, and the Supreme Court has confirmed that interest has to be put on top of the conversion using the US Treasury yields. So it's not the law of Peru. And economically, it's wrong. The 1-year US Treasuries do not provide the compensatory interest required by Peruvian law. It is true that technically there is some real rate of interest embedded in a US Treasury. It's not just inflation, there is a strip of interest above it. But Professor Edwards showed that the Treasury yield on the 1-year bond that the ministry uses, and remember they use a 1-year Treasury in their updating method, includes a real component of a mere 0.77% on average. That's 14 times less than the average rate of return on capital in Peru for this period. Peru simply ignores this economic reality. Peru's experts admitted that they did not even attempt to determine the real rate above inflation in the treasuries. In their words, they had no idea. It hadn't even occurred to them to think about that. Consequently, as Professor Edwards explained, the ministry's use of a 1-year US Treasury for these very long-term updating these very long-term Peruvian obligations is essentially a proxy for inflation updating. It does not include the compensatory interest Peruvian law requires. In its post-hearing brief, Peru makes one other last-ditch attempt to respond. It cites the quantum expert's opinion that the ministry's formula was, as they put it, more than fair because the Treasury yields were 10 to 20 times higher than the stated coupon rates in the bonds of 4, 5, or 6%. But it's remarkable that they would rely on that testimony from their expert's report, because you may remember that during the hearing, we cross-examined them on that, and Peru's quantum experts completely misunderstood how the bonds work. And so on cross-examination, they admitted that their assumptions and opinions about the bond's interest component were wrong. The effective annual interest rates were wrong, the principal discounts were wrong, and the effective face values were wrong. Peru obviously cannot rely on this completely discredited report that its authors admitted was wrong in this very respect. But without that, Peru has nothing to rely on at all. So failing to carry out the core elements of the 2013 Constitutional Tribunal order, engaging in a thoughtful balancing exercise and paying compensatory interest, alone also showed that the ministry violated the minimum standard of treatment. It didn't even comply with the mandate the tribunal had given it. But as we will now see, the ministry also acted arbitrarily and irrationally in many other ways as well. With that, I want to turn to our third point, which is that the ministry's formulas are irrational and arbitrary. So we just looked at what the ministry did not do in implementing the 2013 order, those failures of omission. Now let's look at some of their failures of commission. What they did do was promulgate 3 valuation formulas in as many years, each of which is arbitrary and irrational. The ministry's first attempt came with the February 2014 Supreme Decree. Now, imagine for a second that you're a bondholder like Mr. S, 94-year-old man who's had 10 children. His farm had been expropriated from him many years ago. He just heard about this great new compensation scheme that the ministry has published and wants to figure out how much you're going to get paid. So you pick up a copy of El Peruano and you see this. Now, these complex equations with such seeming precision issued by the venerated Ministry of Economy and Finance to carry out a landmark decision of the Constitutional Tribunal. Even if you couldn't make sense of it, you would assume it was the product of careful consideration, thoughtful analysis, sound economic principle, and a commitment to doing justice. That is what the ministry is supposed to do, not just rob bondholders who've had their land taken from them. But given the stakes, Gramercy and every other bondholder were right to expect no less than that. But in fact, it had none of those characteristics, far from it. The evidence exhibited in this arbitration revealed that it was actually cut and pasted from a desktop study that a local professor, Bruno Seminario, had prepared 3 years earlier over less than a week for the purpose basically of finding a way to pay less than current value that the Constitution required. That was his mandate. Vice Minister Sotelo testified that no one at the ministry critically reviewed Professor Seminario's work and that instead the ministry just accepted what he'd concluded. Maybe that's because they rushed the job. The evidence showed that the ministry waited until December, almost 6 months after the order issued, to start working on the Supreme Decree to implement it, which it had to do by mid-January. And it's a pity that no one at the ministry actually reviewed this formula before dropping it into the Supreme Decree, or, remarkable idea, tested what effect it would have on actual bond values. But thankfully, you had Professor Edwards to do that. When he did, it became clear that it not only produces obscenely low values, but it's also total economic gibberish. I say that advisedly, I'm not making that up. It really is gibberish. Among many, many other flaws, which we don't have time to talk about today, it reduces to the mathematical impossibility of x equals x squared. Now, what could be more arbitrary than that? And yet, this is the formula that the ministry not only promulgated at the direction of the Constitutional Tribunal, it then vigorously defended this formula despite robust criticism for the better part of 3 years. Now, of course, both the ministry and Peru's own experts disown it. At the hearing, Vice Minister Sotelo admitted that the formula was not correctly stated. Peru's quantum experts said they wouldn't carry out the formula and try to make sense of the result because doing so would be, quote, nonsensical. Nonsensical. Pause on that for a minute. This nonsensical formula was the law of the land when Gramercy had to decide whether to assert its treaty rights. And the ministry never solved that problem. The February 2017 version at least offered the promise of much more realistic values, which Gramercy initially took as a promising sign based on that, plus other information they were hearing at the time from within Peru. And those much higher values, including values of over $2 billion for Gramercy bonds, illustrate, and this is very important, how apparently minor changes to the equation's parameters can have a massive impact on value. The precisions themselves drove value from $861,000 to over $2 billion. But the February 2017 formula also, frankly, included some fundamental irrationalities, such as saying that an index, consumer price index, CPI, which is a number, should be expressed in a currency, soles de oro. Rather than clarify what it meant by that, the ministry simply abandoned this formula too. And that brings us to the August 2017 formula, which itself is arbitrary and irrational. A central element of this formula is, of course, the parity exchange rate. We already saw that small changes in the equation can have big consequences on value. But the ministry's parity exchange rate again makes no sense. First, the ministry constructed the parity exchange rate in a way that contravenes the whole purpose of having a parity exchange rate in the first place. As Professor Edwards explained, to do that, to make a parity exchange rate, you have to anchor the calculation to a base period when the two economies are in parity. That's why it's a parity exchange rate. To do so, economists typically use a long average of exchange rates over a long period during periods when the economies are actually in parity with each other, and that becomes kind of the base. Professor Edwards described this completely sensible idea as the basic rule of calculating parity exchange rates. And Mr. Kaczmarek admitted that he doesn't have the expertise to argue to the contrary. He said parity exchange rates aren't something he spends time thinking about. The rule is so basic that even Professor Seminario, who got so much wrong, warned when he did his original report. He said, don't use a single year during a turbulent time. Instead, use a parity exchange rate rather than an actual exchange rate. But the MEF then completely blew it. In their August 2017 decree, they used to calculate the parity exchange rate, they use as the base period a single month in 1969 as the anchor period. That's obviously just one moment, not a long period. And it certainly is not a stable time when the economies of Peru and the United States were in parity. There was massive instability in Peru, a coup, currency controls, and many other problems. And this is a big problem for the rationality of the formula. It makes the parity exchange rate much too high, 2.5 to 3 times too high compared to Professor Edwards' calculation of what a parity exchange rate could be. And a higher parity exchange rate makes the updated bond values much lower. Second, the ministry then made matters much worse by using this distorted parity exchange rate inconsistently. It used it to convert from sols into US dollars in the first case, but then switched and used the actual exchange rate to convert back from US dollars to soles. This inconsistent treatment locks in artificially low bond values and led Professor Edwards to call it a second expropriation. Third, the ministry's formula is tremendously hypocritical. Remember, the whole intellectual justification for dollarization instead of CPI was Professor Seminario's belief that CPI becomes unreliable during periods of hyperinflation. Professor Edwards showed that that is simply not true if you use CPI correctly. His CPI calculations use CPI before and after the hyperinflationary period, but not during it. But one of the peculiarities of the August 2017 MEF formula is that it uses Peruvian CPI during the hyperinflationary period as part of its equation. That would seem to make it impossible for this formula to cure the purported disease that led everyone down this misguided path in the first place. Fourth, the August 2017 formula also converts to US dollars, not at the date the debt was issued, but at the date that somebody happened to clip their last coupon, which is irrational. It makes two bonds that are exactly the same principal, issued exactly the same day, of completely different values. And Professor Castillo explained that given the nature of the obligation that had to be updated, that is about as sensible as updating from the date of the last solar eclipse. So what's the justification for these latest economically irrational and wrong decisions? What is it that Peru and its experts have told you about where they got all this from? Well, nobody knows. If we are to believe Peru's document production, there are no work papers showing where this formula or the anchor date came from. It apparently just fell out of the sky. The ministry apparently just made it up with no study, analysis, consultation, testing, or validation. It does not even have the imprimatur of Professor Seminario or any other economist. Peru tried to say they got the parity exchange rates from the Peruvian central bank. That is not true. The bank provided some data that it does keep about real interest rates, which is a factor that goes into this equation, but it doesn't publish parity exchange rates as such, and it refused to provide them. And in writing back to the ministry, the central bank even cautioned the ministry that a parity exchange rate would be sensitive to the anchor year chosen. The ministry obviously ignored that warning. Hence, the ministry's exchange with the central bank is not a defense of the August 2017 decree. It is instead just one more confirmation of its arbitrariness and irrationality. Now, Peru's, frankly, utter disregard for integrity and rationality with respect to the formulas is shocking. These formulas are not just some academic exercise. They really shouldn't be relegated to a $10,000 desktop study to generate some ideas. They are the single most important element of the Supreme Decrees for Gramercy or any other bondholder. They determine bondholders will, at long last, 4 or 5 decades after having their farmland expropriated, finally receive just compensation, or whether they will instead receive the kind of insulting and derisory amounts that the bondholder process has in fact been paying to many. Yet, even now, after more than 6 years and 3 attempts and our hearing, Peru not only continues to rely on a formula that is nonsensical and upends basic economic principles, but it has not deigned to produce evidence that even attempts to explain why any of these formulas make sense, how the ministry arrived at them, or what other alternatives or factors they even considered. Just like we anticipated in our hearing, in our opening, the hearing confirmed that Peru has offered no witness who dares to defend any of the formulas, and indeed, they all ran away from them whenever we asked them about it. Lacking justification and contrary to basic economic principles, the formulas epitomize arbitrary decision-making. And with that, I would like to hand the floor to Dr. Rosena Costa to address the Peruvian administrative law issues.
Mr. President, members of the Tribunal, I will briefly address Peru's violations of its own laws, a matter that you will recall was the subject of expert reports and testimony by Professor Boulard and Dr. Garcia Godos, and I will also talk about the relevance of those violations to this proceeding. Now, having diligently reviewed the record that Peru describes in its first hearing brief as the voluminous file of documentation that supports the Supreme Decrees, Professor Boulard concluded that those Supreme Decrees violated among other things, the MEF first, the first baby of the hearing. Among other failures, the MEF
We may have more. That's unavoidable in these hearings. I sometimes have a dog which starts barking, so we must be patient with these minor mishaps. It's a miracle that we can all be together and seeing each other. So we have to live with these small difficulties.
Absolutely, Mr. President. I'm a dog owner myself. So I've been guilty as charged many times on Zoom calls. But just recapping then, Professor Boulard concluded that these Supreme Decrees violated very basic principles of Peruvian administrative law. Among other failures, the MEF skirted legal requirements, including the obligation to pre-publish draft decrees for comment. Second, it didn't justify or explain the various formulas in the manner in which it was legally required to do. And third, it even went as far as to evade a mandatory external control mechanism that obligates the executive branch agencies and ministries to submit Supreme Decrees for prior approval. As a result, as Professor Boulard told you, the Supreme Decrees are illegal, unreasonable, and inapplicable. Peru doesn't really deny any of these underlying facts. Instead, it asks the tribunal to dismiss these transgressions as being somehow irrelevant, because in Peru's assessment, the core legal requirements that the MEF chose to ignore were nothing but, quote, hyperformalisms. In other words, what Peru tells you is that it really should just get away with it because it doesn't matter much at all. But that is wrong, and it's wrong as a matter both of domestic and international law. Peru's submission fundamentally ignores that Peruvian administrative law and its central tenets of legality and reasonableness seek to guard against exactly the same sort of arbitrary conduct that is prescribed by the treaty, and in fact by the minimum standard of treatment more generally, as the Tsaya Pshum Tribunal explained. And many tribunals, in fact, often consider the state's disregard for its own laws and its own procedures as indicative of arbitrary conduct in breach of treaty obligations. So yes, while a domestic law violation doesn't automatically amount to a treaty breach, it may do so when domestic and international legal standards overlap, as they do with respect to core values of the rule of law like transparency, reasonableness in decision-making, and non-arbitrary conduct. Peru's undisputed failure to pre-publish the draft Supreme Decrees for comment is actually highly illustrative of that very overlap. Remarkably, Peru continues to assert that the MEF did not need to pre-publish the decrees because no law, in the very technical sense of a norm of a statutory rank, required so. But its expert, Dr. Garcia Godos, conceded that the legal obligation to pre-publish actually arises pursuant to the US-Peru Trade Promotion Agreement, so the very treaty under which we are engaged, which, as an international treaty, was incorporated into Peruvian law with the force of a statute, and thus supplies the requirement that Peru claims was missing. The Supreme Decree that Peru thus seeks to downplay as inconsequential is actually just implementing legislation enacted precisely to give effect to the treaty's objectives. So here we see not only commonality of goals between domestic and international law, but actual identity of obligations. Moreover, the evidence shows that the many other violations Professor Boulard identified are not, as Peru alleges, trivial. The legal requirement to state reasons, for instance, is designed, in Dr. Garcia Godos's own words, to ensure transparency so as to avoid arbitrariness. And these are goals that I think we can all agree are at the heart of the minimum standard of treatment. Now, under Peruvian law, a legally compliant statement of reasons must contain a cost-benefit analysis, which, again to quote Dr. Garcia Godos, is a tool of the utmost importance. Peru says that what it did was sufficient, but as Professor Boulard showed, the MEF's identically worded cost-benefit analyses used indiscriminately for all of the Supreme Decrees, despite the fact that, as Mr. Friedman showed, each contained a very different valuation formula, were just boilerplate. According to a normative guide that applies to the executive branch, they were literally a textbook example of what not to do. And Peru's own Ministry of Justice criticized them, but to no avail. Indeed, a serious cost-benefit analysis could not possibly have been done here because, as Ms. Sotelo confirmed, the MEF never ran the calculations that would have been required to support any serious quantitative analysis of that kind. But Peru's determination in pushing through these Supreme Decrees at basically any cost goes even further. It's also undisputed that the MEF never submitted reports for prior approval by what's called the Multi-Sectoral Commission, thus bypassing a mandatory external control that Legislative Decree 1310 establishes as a condition of validity for Supreme Decrees and administrative procedures. Peru's justification for this basal failure hinges on a single argument, that the decrees were somehow not norms of a general character. And to back that up, Peru cites no authority other than a 2-page legal memorandum the MEF itself prepared. As the Tribunal will recall, however, during the cross-examination of Dr. Garcia Godos, that argument just fell apart. It became clear that it was contrary to Peruvian legislation and to secondary sources, including the sources Dr. Garcia Godos himself had cited, and it was inconsistent even with Dr. Garcia Godos's own opinions on related matters. The hearing testimony also revealed that the MEF's self-serving legal memorandum simply cannot be credited as anything but an ex post cover-up. So what we have here, if we take a step back, is the situation where a ministry thinks it can arrogate to itself the prerogative of choosing whether or not to comply with legal requirements, in fact defeating the entire purpose of having a mandatory external control over its actions. This, we submit, is the very definition of arbitrary conduct. It is conduct that flouts the law, evades accountability, and is based on whim or caprice. To wrap up, Peru's cumulative breaches of its own laws and its failure to follow even its own procedures reveals the sort of systematic and utter disregard for the applicable rules that rises to the level of a breach of international law too. Rather than being insignificant or trivial, as Peru portrays them, these facts provide further evidence of Peru's violation of the treaty's minimum standard of treatment. With that, I will cede the floor to my colleague, Ms. Laveau.
Mr. President, members of the Tribunal, I will discuss how the bondholder process constitutes further evidence of Peru's violation of the minimum standard of treatment under the treaty. As the evidence shows, the process is not only arbitrary by design, but also a massive failure in practice, including for the following 6 reasons. First, Peru imposed the process on bondholders with absolutely no consultation or transparency. Not once in any of Peru's multiple attempts to establish either the formula or the process did Peru offer any opportunity for bondholders to be heard. Second, this process requires bondholders to blindly give up their right to obtain the current value of their bonds in local courts without even knowing how much they will receive and how long it will take? Third, it is a process that is unnecessarily complex and moves extremely slowly. In fact, based on Peru's own evidence, it takes on average over 4.5 years to obtain payment. And at the pace that it had been going, it would take decades to bring all pending claims to conclusion. Fourth, this process leaves complete discretion to the MEF to decide when and how to pay bondholders. Fifth, it provides no effective recourse to bondholders who are unhappy with the result, as it doesn't even allow them to challenge the MEF's formula. And finally, it pays practically nothing. As Vice Minister Sotelo testified, 6 years into the process, Peru had only paid in cash the equivalent of $300,000. Let me repeat that. $300,000. It is therefore not surprising that the bondholder process has attracted only a tiny fraction of the outstanding loan bond debt, and that it has only resolved so little of that debt. As Professor Olivares Caminal estimated, only about 8.7% of the total outstanding principal had been submitted to the process, and only 0.3 had been resolved as of August 2019. Now, I will submit that these numbers look very small, but they will look even smaller when you compare them to the fact that a successful bond resolution typically engages a 90% participation rate. Now, at the hearing, you will recall that Minister Castilla could not even bring himself to defend the results of the bondholder process. Instead, he admitted that they are, and I quote, disappointing. And he was not the only one. Even Dr. Wheeler, the expert that Peru hired to rubber stamp the bondholder process as effective and functioning, also refused to validate the results of that process. He indeed conceded that most observers would consider the amount paid so far as a pitiful result. It is therefore also not surprising that the dropout rate has been so high. In fact, 3 out of 5 bondholders chose not to request payment after finding out how much they would receive from the MEF. In other words, those are bondholders who went through the process for several years, and after having gone through that process, decided not to request payment. And if Peru had opted to cross-examine the bondholders who submitted evidence in those proceedings, those who actually went through the process themselves, they too would have confirmed the unfair and arbitrary nature of the process. For example, Mr. Friedman mentioned Mr. S. earlier, a 91-year-old twice widowed father of 10. He would have explained that the process was, and I quote, an insult and a joke after he received $240 for the expropriation of 56 hectares of land some 45 years ago. Mrs. L, who received just $67 for her family's farm, would have described the process for you as a scam and a trap for bondholders, seeking to deprive them of fair compensation. So together, those two bondholders received less than what Peru paid Dr. Wheeler for just 1 hour of his time. 1 hour of his time. Sadly, the experience of these bondholders is not an anomaly, but is illustrative of how the process works in practice. These results are simply appalling, and as Professor Olivares Caminal testified, are unsurprising in light of the fundamental flaws in the design of the process. Now, while certain elements of it, taken in isolation, may appear to have their own logic, the process as a whole completely fails to achieve the objective for which it was allegedly created. It contains none of the hallmarks of an effective process for resolving sovereign debt obligations. So what does Peru have to say in response to all of this? Well, Peru is asking that you turn a blind eye to this testimony and that you take at face value its claim, and I'm sure you will no doubt hear this tomorrow, that the process is advancing, that bondholders are being paid, and that the process allegedly comports with some international norms. But the results of the process are entirely inconsistent with Peru's claims. Even Dr. Wheeler was incapable of articulating how the bondholder complied with those international norms. For example, he could not explain how the payment mechanism worked in practice. He also was not able to explain what the formula meant. In fact, you will recall that he admitted that he did not even consider the formula at all. He also admitted that he cited to the two bondholder witnesses to which I referred earlier as evidence that the process was functioning without giving any consideration at all as to the amount that they received from the MEF. In other words, Dr. Wheeler's testimony was entirely based on the existence of some kind of bureaucratic process, no matter how arbitrary, unreasonable, and grossly unfair the results. But Peru's attempt to elevate form over substance fails. Under international law, the mere existence of a process does not excuse injustice. In this case, the bondholder process is not a defense of, but the very basis of Peru's violation of the minimum standard of treatment. Thank you for your kind attention. I now turn the floor back to Mr. Friedman.
Thank you, Ms.
And
Lavo.
I will now very briefly touch on effective means and national treatment, although we mostly refer you simply to our briefs on those subjects. First, with respect to effective means, I would just draw your attention to the fact that the treaty MFN provision in Article 10.4 obviously applies to substantive protections, which is reinforced by carving out one procedural issue, which is other dispute resolution clauses. And that Gramercy's case on this is actually fairly simply expressed as follows, that through the August 2013 Constitutional Tribunal resolution, the one that made the bondholder process the MEF would create mandatory, and the Supreme decrees, that what the Constitutional Tribunal and the MEF did was reverse what had previously been the case, that was optional mechanisms for dollarization from the 2014 order, and instead impose a solution that deprived Gramercy of the right that it had up till that moment to go to Peruvian courts and get CPI plus interest. And in that, which was an effective means, and then substituted for it an ineffective means of the bondholder process. But we've submitted on our papers on the other legal issues. With respect to national treatment, under Article 10.3, I simply want to point out to you that the evidence really has confirmed that there definitely was a discriminatory animus against Gramercy in this bondholder process, and indeed in the treatment of the bondholder issues. You'll recall that in the 2014 Supreme decrees, Peru introduced a provision that places legal entities that bought the bonds for so-called speculative ends very last in the queue for payment. There was no evidence of where this came from or why from the witnesses. Neither Minister Castilla nor Vice Minister Sotelo had any explanation for it. And then when pressed and when said, well, look, you've called Gramercy a speculator many times before, this must be a provision about them. Is it about them or anybody else? Vice Minister Sotelo resisted giving any further answer because she was under oath. It's pretty plain from the evidence that this decree and the treatment of bondholders generally was motivated, at least in part, by animus against Gramercy. From the outset of this arbitration, Peru has accused Gramercy of being what it called a hedge fund speculator, clearly putting Gramercy in that last payment priority bucket. When Gramercy commenced this arbitration, after years of seeking to reach a global consensual resolution of the land bond debt, then President of Peru, Pedro Pablo Kuczynski, publicly declared that I don't think we owe Gramercy anything. Again, last year, then Chief Justice Urviola urged Congress not to pay anything to what he called the vulture Gramercy. It was the Chief Justice of the Constitutional Tribunal. And in its post-hearing brief, Peru reiterated that Gramercy is entitled to nothing, nothing. Accordingly, we suggest that although this is just about cash payment priorities, that and the other evidence in the case reveal a clear discriminatory animus in the treatment of the whole bondholder issue against Gramercy, which is forbidden by Article 10.3 of the treaty. And with that, Mr. President, we propose to conclude our submissions on merits and take a break before turning to quantum and jurisdiction, if that's acceptable to you.
Absolutely. If there is no question from my colleagues,
Not for me. Thank you, sir.
and from Professor Stan.
Well, maybe I wait till the end.
Very good.
I might have some questions.
Excellent. So it's now here in Spain, 1643. Shall we come back at 17 Spanish time, which should be, Marisa, can you help me?
11 a.m. Eastern.
11 a.m. Yes.
11 a.m.
Yes,
We will be back at 11 a.m. Thank you very much.
Thank you.
Welcome back. We resume the hearing, and I now give the floor back to claimant.
Thank you, Mr. President, and good morning and good afternoon, Mr. President and Professor Stern and Mr. Dreimer. I will be addressing quantum, and quantum here is really quite straightforward. As Mr. Friedman described, the land bonds have an intrinsic legal value mandated by Peru's constitution and laws. Peru's treaty breaches deprive Gramercy of that value. And so the obvious remedy, and in fact, the only remedy that will provide full reparation, is to order Peru to pay Gramercy what it owes, namely, the full intrinsic value of Gramercy's land bonds under Peruvian law. And if we could get our slides up, that would be good. As Mr. Friedman described, that full intrinsic value consists of the value of the unpaid principal updated for inflation in today's currency, plus compensatory interest on that updated principal. That full intrinsic value was at least $841 million in May 2018, and of course it's even higher today because of accumulating interest. That's clearly the value if the Constitutional Tribunal's 2013 order breached the treaty and Gramercy is entitled to CPI updating from issuance, but it's also the value even if the 2013 order was proper and the breach was limited to the MEF's arbitrary international implementation of that order. In my remarks today, I will first review why Gramercy is entitled to the full intrinsic value of its bonds as a legal matter. And could I have the next slide, please? Then I will address why that value was at least $841 million, whether or not the 2013 CT order breached the treaty. To determine the proper measure of damages, the starting point is the applicable legal standard. And here, that's undisputed. It's undisputed that the full reparations standard applies. Within that context, though, Peru attempts two categories of legal arguments. First, that Gramercy has not met its burden of proof, and second, that the measure of damages should be the bond's market value rather than their intrinsic legal value. Neither of Peru's arguments is right. Peru's purported arguments about quantum legal standards actually just rehash Peru's merits arguments. If Peru is wrong on the merits, those arguments also fail. And that's clear right from the start of the damages section of Peru's post-hearing brief. Peru begins by arguing that Gramercy is seeking, quote, more than is available under Peruvian law, and then it cites the bondholder process as the authoritative determinant of Peruvian law. That's just a restatement of Peru's merits case. Peru's primary defense on the merits is that current value means whatever the MEF says it means, but that's simply not the case for the reasons that Mr. Friedman has described. But Peru's burden of proof arguments just repeat that same claim over and over again in different guises. As shown here, Peru's argument that Gramercy has not met its burden of proof with respect to damages is an obviously incorrect merits argument. Peru argues that all it owes is the nominal value of the bonds without any change to their terms. But that's exactly the argument the Constitutional Tribunal rejected in its 2001 decision. So it's not only a merits argument, it's an obviously incorrect merits argument. It does not cast any doubt on the certainty of Gramercy's proof of its damages if Gramercy is right on the merits. Peru's causation argument is more of the same and fares no better. Peru again just repeats the obviously wrong claim that Peru is not required to pay more than the original nominal terms of the bonds, and then repeats its merits argument that the law is whatever the MEF says it is. The bottom line on Peru's burden of proof and causation arguments is that they actually don't address either the burden of proof or causation at all. In fact, Peru has not shown or even attempted to show any inaccuracies in Gramercy's computation of the damages if if Gramercy is right about the merits. Peru's only actual quantum argument is its claim that Gramercy is entitled only to the market value of its land bonds and not their full intrinsic value. That is a damages argument, but it just doesn't make sense. What Gramercy has been deprived of is the full amount of money Peru is obligated to pay, and not some lesser amount that Gramercy might be able to get if it sold its bonds. If Gramercy has the legal right to be paid X, it would be irrational to award less than X based on market value. Now, Peru's argument that intrinsic legal value is a quantification that is not recognized under international law is simply wrong. Gramercy has cited, without rebuttal, several cases in which international arbitral tribunals and courts have adopted the intrinsic value of debt obligations as the proper quantification of damages, and that includes landmark judgments by the Permanent Court of International Justice that upheld gold clauses to preserve the value of inflation-eroded bonds. Tribunals only look to market value when you need to do that. That happens when the asset that was taken doesn't have an independent objective value. But here, what was taken was a right to be paid a certain sum of money. These authorities and the additional authorities in our briefs show that in that situation, tribunals and courts have not hesitated to award the full amount of the obligation. And that totally makes sense. Otherwise, sovereign debtors could unilaterally reduce the value of their obligations and stiff investors just by creating uncertainty about their willingness to pay in order to depress the market value of their bonds. So in sum,
Mr. Reel,
yes.
I get urgent messages for you that you are going too fast.
Yes, thank you, Mr. President. I will.
And if you could please let's give it now 10 seconds for the poor interpreters and court reporters to catch breath again, and you must go slower. Please.
Yes, my apologies, Mr. President, and the tribunal to you and to the reporters. I will proceed at a slower pace. Is it okay to proceed, Mr. President?
Of course, Mr. Reed, thank you.
So to sum up this point, in order for Gramercy to be restored to the same position it would have been in, but for Peru's treaty breaches, Gramercy must be awarded the full intrinsic legal value of the land bonds. I'll turn now to what that full intrinsic value is. Gramercy's bonds were worth at least $841 million in May 2018. That's undisputedly true if Peru reached the treaty, either through the MEF's interference with the CT's deliberations and the whole 2013 order dollarization scheme, or by cutting off Gramercy's access to Peru's courts. But it's also true if Gramercy is wrong about those breaches, and you instead find that the CT's 2013 order and the MEF's intervention to procure it did not violate the treaty. Let's look at each of those scenarios in turn. First, if Gramercy is right that the 2013 CT order is invalid, we know what the but-for world would have been. In fact, this case is quite unique in that there's a document that specifically describes that but-for world. That's the original majority opinion before it was transformed with whiteout. But for the MEF's intervention, that opinion would have issued as the majority opinion, and would have definitively stated Peru's legal obligations under the land bonds. Consistent with the 2001 CT decision's interpretation of Peru's constitution, the value of the land bonds under that original CT majority opinion would have been calculated by adjusting for inflation using CPI from issuance and then adding compensatory interest at the original coupon rates. Professor Edwards presented the formula to do that, and that's shown on this slide. Peru has never challenged the mathematical accuracy either of this formula or of Professor Edwards' computation that it would value Gramercy's land bonds at $841 million as of May 31st, 2018. Now, we also know that Gramercy would have likely obtained that same value computed in exactly the same way in Peru's courts if the CT had not terminated its access to the courts by making the bondholder process the exclusive remedy for bondholders. Peru's quantum experts confirmed at the hearing that the operative expert report in the Pamalka case valued Gramercy's land bonds at issue the same way as the CT's original majority opinion did. It used Peru's CPI to update for inflation from issuance and then added compensatory interest to that updated amount at the original coupon rate. Peru can't escape that Pamalka provides the best evidence of the value Gramercy would have received for its land bonds in court. Peru tries to suggest that Gramercy was not actively pursuing litigation, but that is false. Gramercy had submitted conciliation requests, which was a mandatory step prior to filing a lawsuit for all of its bonds, 100%. It was thus actively seeking judicial determination for its entire portfolio before Peru shut down that possibility. There were only 44 bonds, Gramercy bonds, involved in the Pamalka case, but those bonds were big and they represented more than a quarter of Gramercy's portfolio by value. And Gramercy had other active cases in addition to that case. So whether using CPI is based on the but-for world in which the illegal 2013 CT order had not issued, or instead on the value Gramercy likely would have achieved in litigation, if Gramercy is right that the CPI method applies, it is undisputed that its bonds were worth $841 million in May of 2018. All right. Do I need to go even more slowly, Mr. President? I will try. Let's look now at the other scenario, the one where we assume the 2013 CT order did not breach the treaty, notwithstanding the MEF's improper intervention to procure it on false pretenses. Even in that scenario, the evidence at the hearing established that Gramercy would have received about the same amount under the CT's 2013 order as it would have under the CPI method if the MEF had implemented the 2013 order in an economically reasonable manner. Unfortunately, that's not what the MEF did. As Mr. Friedman described earlier, the MEF instead imposed arbitrary, irrational, and expropriatory valuation formulas. Those formulas fell far short of what the 2013 CT order required in two fundamental ways. First, the MEF's arbitrary parity exchange rate formulas produce irrationally high parity exchange rates that strip the land bonds of much of their value. And the MEF compounded the effects of that error by illogically applying the parity exchange rate to convert from soles to dollars before inflation updating, but then using the much lower nominal exchange rate to convert back from dollars to soles after the inflation updating. The second error is that the MEF's supreme decrees do not add the compensatory interest that the CT's 2013 order clearly mandates. At the hearing, Professor Edwards described how these two errors can be corrected to obtain a valuation that is consistent with the 2013 CT order. The parity exchange rate errors can be corrected in one of two ways. First, by using an economically rational parity exchange rate formula, or second, by using the MEF's formula consistently, applying it to both currency conversions instead of starting with the parity exchange rate in one direction and then shifting to the lower nominal rate after the inflation updating to convert back. The omission of compensatory interest is, of course, easily corrected. You just add the compensatory interest in. Professor Edwards calculated the values of Gramercy's land bonds under each of these two methods for fixing the MEF's parity exchange rate errors. In each case, he calculated compensatory interest using the original coupon rates, which is what Peru's Supreme Court has done in its multiple decisions implementing the 2013 CT order. The formulas that Professor Edwards used are shown here. It's a lot of math, sorry about that. They were also included in Gramercy's post-hearing briefs. Professor Edwards started with the formulas in the August 2017 Supreme Decree and then made the corrections that are shown here in red that correspond to what I've described in words. Peru has not disputed either the mathematical accuracy of these formulas or the valuations that Professor Edwards calculated using them. If there were any questions about that, though, the tribunal could deal with that by asking both parties' experts to jointly corroborate these equations and their results. So what this all shows is that regardless of whether you find Peru's treaty breach included the wider set of events, including the CT 2013 decision, or you exempt that decision and determine that Peru's treaty breach was limited to the MEF's implementation of that decision, either way, you come out with the same number, about $840 million as of May 2018. Now, that $840 million is the amount Gramercy would have received from Peru's courts or under a proper implementation of the 2013 order, but it's actually not enough to affect full reparation. Gramercy's land bonds are worth almost $1 billion more if compensatory interest is calculated at a rate that fully compensates land bond holders for the actual value of their lost opportunities. That's the 7.22% rate Professor Edwards estimated. The only difference between the $841 million number I've been describing and Professor Edwards' $1.8 billion valuation is using that 7.22 rate instead of the original coupon rate as the compensatory interest rate, which is the variable R in the CPI method formula shown here. The interest rate has a very large impact on value, and that's really just what you would expect. Compensatory interest has been accumulating for several decades, up to 50 years or even more for some of the bonds. Now, we understand that $1.8 billion is obviously a big number, but there's nothing exaggerated about it. There's nothing illegitimate about it. The 7.22% rate used to calculate it is actually a conservative estimate of the actual historical rate of return in Peru. That's the rate of return that Peruvians on average actually earned on their investments in Peru during the time since the land bonds issued. Professor Edwards used a well-established econometric method to estimate that rate of return. It made consistently conservative assumptions in his calculations. The MEF itself used exactly the same method in 2011 and reached a similar result. The MEF's 11.6 figure shown here is its estimate of the overall return on capital, whereas Professor Edwards' 7.22 is the return on debt, which is typically lower than the return on capital overall. You will likely recall Professor Edwards' testimony that he reached a higher 11% estimate of the return on capital, but used the lower 7.22 to be conservative, the 7.22 return on debt. So the $1.8 billion obtained using that 7.22% rate is what would be required to effect full reparation. But even if you do not view full reparation through that lens, and you instead look to Gramercy's entitlement, either but for the 2013 CT order or under economically rational implementation of that order, Gramercy's damages were at least $841 million as of May 2018. Peru tries to evade this analysis by accusing Gramercy of advancing, quote, inconsistent damages claims, and by suggesting that considering what the CT actually ordered in 2013 would somehow deny Peru due process. Those claims are just not true. There is no inconsistency in the damages claims Gramercy has asserted. From the start of the arbitration, Gramercy has always argued that it is entitled to an award of the full intrinsic legal value of its land bonds. Nor is there any inconsistency in Gramercy's arguments about the computation or amount of that intrinsic legal value. As shown here, in each of its pleadings and in its opening argument at the hearing, Gramercy has consistently argued that the intrinsic value consists of inflation updating using CPI from issuance and then adding interest to compensate for foregone opportunities. And Gramercy has consistently asserted that the intrinsic value of its portfolio as of May 2018 was $1.8 billion if computed using the 7.22% rate, and $841 million using the original coupon rates. Peru's attempts to paint Gramercy's claims as inconsistent center on Figure 1 from its merits and quantum post-hearing brief, which is reproduced on the next slide. This figure is misleading, but in any event, it actually confirms that Gramercy has consistently argued for CPI updating plus compensatory interest. The Edwards 1 line shows CPI adjusting plus compensatory interest at the 7.22% rate. Gramercy has never claimed the damages shown in the Edwards 2 line. That was an illustration from Edwards' report. Alternatives 1, 2, and 3 are all actually the same computation. As clearly shown in the figure itself, all 3 update for inflation using CPI, all 3 update from issuance, all 3 use Lima CPI, and all 3 apply compensatory interest at the original coupon rates. That's because, as Gramercy described in its brief, all 3 of these purported alternatives were computed using exactly the same CPI method formula. They are different alternatives only in the sense that the same approach was used both in the CT's original majority opinion and by the expert in Pamalka, and Gramercy discussed both of those sources in its reply. And then in its post-hearing brief, it corrected the valuation they produce to incorporate a minor correction that Professor Edwards identified during his hearing testimony. Now, I want to pause briefly on the method from the CT's original majority opinion. Peru, as you see here, lists that method in its Figure 1 as something that Gramercy argued in its reply, but then elsewhere in its post-hearing brief, Peru claims that method is inadmissible based on a false allegation that Gramercy's reliance on the CT's original majority opinion is, quote, an entirely new damages claim that Gramercy allegedly introduced for the first time in its post-hearing brief. That's just not true. As shown on the next slide, Gramercy explained and relied on this approach in its reply, and Professor Edwards computed and presented the value of Gramercy's land bonds under this approach in his second expert report, which Gramercy submitted with its reply prior to the hearing. Returning back to Peru's Figure 1, the last 2 valuations are alternatives 4 and 5. Those are just the 2 different ways I have described that Professor Edwards corrected the arbitrary aspects of the MEF's Supreme decrees to eliminate their inconsistencies with the CT's 2013 order. Alternative 4 uses Professor Edwards' parity exchange rate formula, and alternative 5 applies the MEF parity exchange rate consistently. Those are not damages calculations that Gramercy has asserted as part of its case in chief, and they do not show any inconsistency in the damages claims Gramercy has asserted as part of that case. Rather, they show what the value of Gramercy's bonds would be if you were to find that the CT's 2013 order did not breach the treaty, but under an economically rational implementation of that order. Peru also tries to argue that it was procedurally improper for Gramercy to introduce those calculations in its post-hearing brief. Peru characterizes them as, quote, belated submissions of alternative damages claims. But that's also just inaccurate. They're actually directly responsive to evidence Peru submitted for the first time with its rejoinder and to a question that the tribunal asked the parties to answer based on that evidence and testimony about it at the hearing. In an expert report that Peru submitted with its rejoinder, Dr. Hunskopf introduced and relied on a number of Supreme Court cases applying the 2013 CT order that had not previously been in the record. At the hearing, Dr. Hunskopf testified that those cases applied the 2013 order correctly. In its post-hearing questions, the tribunal invited the parties to address the legal consequences of one of those cases. And in response to that question, but in any event, in light of Peru's new evidence, it was entirely appropriate for Gramercy to provide the tribunal with computations of the value of its portfolio under the 2013 CT order as informed by those later Supreme Court cases. Moreover, even without Dr. Hunskopf's late-breaking evidence, it would have been appropriate for Gramercy to submit these calculations. If you were to conclude, based on the evidence at the hearing, that the 2013 CT order did not breach the treaty, but the MEF's implementation did, you would have to figure out damages under that scenario. And those damages would equal the intrinsic legal value of Gramercy's bonds under a proper implementation of the 2013 CT order. It would be well within the scope of your discretion in that circumstance to order the very computations Gramercy has submitted. When Gramercy submitted these computations, it did not introduce any new evidence. It merely applied math to the existing evidence. It thus did no violence to Peru's procedural rights for Gramercy to present those computations in its post-hearing brief in a manner that gave Peru ample opportunity to review them and to contest their accuracy if it had chosen to do so. In short, Peru's efforts to tar Gramercy's damages claims as inconsistent or procedurally improper are grounded in misrepresentations of the record and in no way undermine the legitimacy of those claims. I would like to close out the damages presentation with the observation that none of the damages methodologies I've been discussing would generate the severe budget impacts that the CT worried about in its 2013 order, even if they were applied generally to all of the land bonds that are still outstanding. In procedural order number 11, you reminded the parties of your interest in knowing the amount of land bond debt that remains outstanding. The best evidence in the record suggests that the total outstanding unpaid principal is 2.52 billion soles de oro. Remarkably, it was Gramercy and not Peru that has assisted the tribunal in ascertaining that number. This slide shows Professor Olivares Caminal's estimate based on documents in the record. For its part, Peru continues to claim that there is no record of the outstanding bonds, and it says that such records, quote, disappeared. But Peru has not disputed the accuracy of Professor Olivares Caminal's calculation. Even if none of the coupons supporting that 2.52 billion have been lost or destroyed, which is a very conservative assumption, paying the full updated value of that entire unpaid principal will not have any severe effect on Peru's budget. Professor Edwards estimated that the full updated value of all the outstanding principal would be about $5.6 billion if it were updated using the dollarization method specified in the 2013 order, but with the parity exchange rates that Professor Edwards calculated and compensatory interest at the original coupon rates. The figure would be very similar using the CPI method from the CT's original majority opinion in the Pamalka case, since the value of Gramercy's portfolio is very similar using that method. It is undisputed that Peru could easily pay that amount, and that has been independently confirmed by the Moody's rating agency, which Minister Castilla testified is one of the ratings agencies that Peru itself pays to rate its sovereign debt. Moody's estimated the total outstanding debt to be $5.1 billion as of the end of 2014, and expressed confidence that Peru could finance that level of payout in a way that would not materially affect its fiscal dynamics or creditworthiness. Now, the potential impact on Peru's budget, if the determination here were applied more generally, is not, strictly speaking, relevant to damages. But the tribunal can nevertheless take comfort that Gramercy is not seeking a level of damages that would place Peru in dire straits if the same valuation were applied to all land bond holders. Gramercy has amply demonstrated that Peru was obligated to pay at least $841 million on its land bonds, whether or not the 2013 CT order breached the treaty. The MEF's supreme decrees would have paid only about 4% of that amount at most. They clearly breached the treaty. Under the full reparation standard, Peru must now, at long last, be compelled to pay what it owes. And with that, I'll turn things over to Ms. Popova to address jurisdiction.
Thank you. Thank you, Mr. Reel. And now we will give the floor to Ms. Popova.
Thank you, Mr. President. Good afternoon, Mr. President, members of the Tribunal. Ms. Berkland and I will keep our remarks short because the last brief on jurisdiction was Gramercy's post-hearing brief, and we haven't yet heard Peru's closing on its own jurisdictional objections, but we will, of course, be happy to answer any questions that you have for us tomorrow. What's remarkable, though, is that the hearing so thoroughly undermined Peru's objections that the whole house of cards has now collapsed. Faced with testimony that across the board destroys every single one of its objections, Peru has ended up pivoting to two admissibility objections whose very premise is that jurisdiction otherwise exists. First, denial of benefits, and second, abuse of process. Now, neither of those can help Peru, but it goes to show that Peru's manifold jurisdictional objections are not really based on a principled interpretation of the clear terms of the treaty. Time and again, Peru either ignores or mischaracterizes the key legal issues and evidence. Underlying all of Peru's arguments on jurisdiction is instead a thinly veiled ideological proposition that investment management firms and the financial products in which they invest do not deserve treaty protection. But nothing in international law compels such a result. And under this particular treaty, with its express terms, its structure, and its specific historical circumstances, nothing could allow such a result. For good order, we will deal first with Peru's objections as they had been, and then briefly with denial of benefits and abuse of process. Now, in the interest of time, I will skip temporal jurisdiction. There is really no question that you have jurisdiction over breaches occurring several years after the treaty came into force, and I'd refer you to our briefs on that point. So beginning first with the material jurisdiction. The hearing confirmed that Gramercy made a covered investment. In the extensive evidence that you heard from both parties' treaty negotiators, as well as the documentary record of the treaty's negotiation and the context and purpose of the Andean FTA from which it arose, that whole rich tapestry of evidence about what the state parties here intended to achieve, you will not find a single thread that says that this kind of bond, this kind of public debt, this kind of restructuring of a long stagnant state debt in the interests of both the state and the whole class of bondholders, that this was somehow silently excluded from the open-ended and deliberately broad coverage of all forms of public debt except state-to-state loans. First, Peru had originally argued at some length that the land bonds were not debt, that they were not bonds in the first place, that they didn't have the same features as other kinds of sovereign bonds. Well, that fell apart at the hearing. An immediate giveaway for that is that in its post-hearing brief, all that Peru says about this is one single sentence to the effect that, quote, the fact remains that they are not bonds or debt, with no citation. And that's because nothing in the hearing testimony supports that view. Peru's witness, Vice Minister Sotelo, readily admitted that the land bonds are internal domestic public debt. Peru's expert, Professor Guidotti, readily admitted that they met his expert definition of the essential characteristics of a bond. And both he and Professor Olivares Caminal destroyed Peru's argument that these bonds were somehow radically different in nature from all other kinds of state-issued bonds. As Professor Olivares Caminal put it, a 1969 Chevy Camaro is still a car, even though it has no airbag like a Tesla does. So instead, Peru turned to Professor Riesman, who of course is not an expert on sovereign finance. In his reports, Professor Riesman had disputed the fact that bonds were public debt based on what he had called the common understanding of public debt in the investment context, he said, and also what he called the US understanding. But he admitted on cross-examination that of course one would also have to look to Peru's understanding of whether the bonds were public debt, not just the United States, and that he had not done that. And instead, what he had done is to turn to things like the mission statement for a now defunct US internal agency, or a paper that he wrongly attributed to the IMF, or the caption to a table about GDP produced again by the United States' CIA, or, of course, the website www.economicsdiscussion.net. Now, you remember we looked at that together, and I'll spare us from looking at it again. But Professor Riesman admitted, among other things, that it was essentially a platform for people to upload their own papers, which has no academic affiliation or peer review of any kind, and that the text that he'd relied on was written by somebody whose identity or credentials he didn't know, and which merely popped up on the internet late at night. And he ultimately admitted, of course, that one should not, in fact, rely on sources of this kind in interpreting the US-Peru treaty. Moreover, Peru has never attempted to distinguish this case and this treaty from all of the other cases in which tribunals have found that government bonds and other forms of state debt are indeed investments. Cases like FedEx, Abaclat, Alemani, Ambiente Oficio. There's even another recent decision to that effect earlier this year. Conversely, Peru has not denied that the US-Peru treaty is radically different in its text from the treaty at issue in Postova, which is the only case in the record to find that government bonds were not a covered investment. Now, indeed, Peru's suggestion that the bonds and Gramercy's investment in them did not have the characteristics of an investment also fell apart at the hearing. Now, of course, an asset only qualifies for protection if it has those characteristics. The treaty essentially says an investment is every kind of asset that is an investment, as long as it's owned or controlled by an investor. And this treaty's use of or, not and, means that no particular characteristic of investment is actually required. And Ambassador Algai, you'll remember, told you that the reason that they had done it that way, the whole point is to make the treaty purposefully broad and flexible over time. As he put it, the assets on the treaty's illustrative list, like bonds, like debt instruments, are the ones that the state parties agreed are more likely to have those characteristics. They're presumed to have them. And as he put it in the context of the bonds, in some cases, it's more obvious than in others. Now, state-issued bonds fall into the more obvious category. That's why states issue bonds in the first place. That's why footnote 12 of this treaty confirms that bonds are the kind of debt instrument that is more likely to be protected. That's why Annex 10F and footnote 13 of this treaty confirm that public debt is protected. That's why this treaty covers not just bonds issued by a company or debt instruments between private parties, but effectively all kinds of Peruvian state debt owned by private investors. And that makes perfect sense. Long-term debt is a quintessential form of investment, and long-term debt issued by a state is a quintessential form of investment in a state. If you stop Madame Lambda on the street, whether it be Main Street or Wall Street, and you ask her, what's an investment? She would likely say, stocks and bonds. That's the ordinary meaning of the term, which after all is the whole point of the treaty interpretation exercise in the first place. And what's more, here we are not just dealing with a passive investment in a handful of financial instruments or a couple of shares in a company. We're dealing with a considered strategy to leverage Gramercy's unique expertise and proven track record in order to resolve a whole category of stagnant debt, to improve Peru's credit ratings, to attract more foreign direct investment, to create a secondary market, to bring liquidity to thousands of individual bondholders, as Gramercy had successfully done in many other emerging markets. So there's really no dispute, again, that in making that investment with that strategy in mind, Gramercy committed capital or other resources. In fact, it did both. Gramercy didn't only commit $33 million in capital, but also significant other resources over the years to develop and implement its reverse inquiry bond swap proposal, which Mr. Königsberger testified about at length and which Peru has essentially completely ignored. Of course, in developing that strategy, Gramercy believed it would make a profit, not just for itself, but for all bondholders in catalyzing a consensual restructuring, as Mr. Königsberger explained. And if that principal strategy didn't work, Gramercy believed it could always have the safety net of recovering the current value of its bonds through the Peruvian courts. And of course, like any investment management firm, it stood to gain management and performance fees on its investment. Now, the flip side of that is that Gramercy also assumed risk. As Mr. Herrera confirmed in the treaty says, buying state debt entails commercial risk. And Gramercy took non-commercial risks too, such as opportunity cost, reputational risk, loss of fees, and Peru really didn't cross-examine any of Gramercy's executives about their testimony on that front. And finally, although this is actually irrelevant as a legal matter, Gramercy's investment in the bonds also had the characteristic of contributing to Peru's economic development, that long-lost fourth prong of Cellini. Now, here too, I refer you to our briefs for the doctrinal point. Peru cannot use the preamble as a proverbial red pen to write this additional requirement into the treaty in this UNCTAD arbitration, contrary to cardinal principles of public international law, to Ambassador Algai's testimony, to decades of arbitral jurisprudence, and even, as you'll remember, to Professor Reesman's own academic writings, as I explored with him on Cross. In any event, on the facts, that requirement doesn't help Peru either. Again, Mr. Königsberger explained how Gramercy's investment in the land bonds would help Peru achieve what he called a virtuous circle of creditworthiness, the end of the era of default for Peru, better ratings than they might have had otherwise, and foreign direct investment that is mutually beneficial. He said, I've been doing this 32 years. It is always beneficial for the state. And he gave you some specific examples of that, which Peru again did not challenge. He described how Gramercy has had great success working consensually with states to resolve claims that seemed otherwise unable to be resolved. And consistent with that strategy, Gramercy sent Peru several proposals for exactly that, for a reverse inquiry debt swap proposal that explained the benefits of the proposal for Peru and proposed a reinvestment program. You see here a passage from a presentation that Gramercy sent to President Garcia outlining those benefits. Now, Professor Olivares Caminal corroborated those macro and microeconomic benefits. He testified about how Gramercy's investment created a secondary market, injected new foreign direct investment, had a multiplier effect, and would have catalyzed a hugely beneficial restructuring had Peru not stubbornly refused to even talk to Gramercy about that. And Peru did not challenge, didn't even want to hear Mrs. G's first-hand account of the microeconomic benefits that Gramercy's infusion of capital had for her and all of the other bondholders that sold to Gramercy. Now, Mr. Herrera, who remember was the former head of Peru's investment promotion agency, Proinversión, he readily agreed that bond swaps and productive restructurings are beneficial for Peru. And that is exactly what Gramercy was proposing. Finally, Peru's suggestion that this particular kind of bond or bond restructuring was nevertheless somehow intended to be excluded also fell apart at the hearing. Now, of course, both treaty negotiators and even Professor Reisman agreed that what defines the coverage is, of course, the text. Certainly can't be the silence of Peru's own negotiating minutes that Mr. Herrera had suggested in his statement. And the contrary approach, you'll remember, would make Hegel blush, Professor Reisman said. Now, the treaty negotiators agreed that after extensive negotiations, the only kind of state debt here that was excluded was state-to-state loans. In fact, both treaty negotiators specifically confirmed that the land bonds were not excluded from the treaty's scope. The parties didn't put the bonds on the negative list. Mr. Herrera agreed that the treaty protects assets unless a reservation is expressly stipulated, and there is no such express exclusion for the bonds. He even agreed that sui generis kinds of bonds, like the Brady bonds, those were covered under the treaty, even though they too, like the land bonds, were not expressly mentioned either in the treaty or the negotiating minutes. And Ambassador Algaya said that nowhere in the agreement is there an express exclusion of the kind that would have been required. Peru could easily have carved out the bonds from the treaty's broad coverage the way that it did other forms of public debt, or other kinds of assets, or other kinds of state measures that it found particularly politically sensitive. Things like bullfighting or tuna fishing for the US. There is a mechanism in the treaty to do that, and the state parties here did not. And what's more, Peru did not do that for the land bonds, not because it couldn't have anticipated that at some later point in the future there would be this form of investment that was the land bonds. It didn't do that in a context in which it knew, as Mr. Herrera and Dr. Hunskopf conceded, it knew that the bonds could be acquired by US investors and that disputes could arise about them. In fact, disputes had arisen about them, some of which were so important that Ambassador Algaya, who was the senior US official personally dealing with this political issue at the time, he described them as the proverbial Damocles sword over the whole enterprise. And what's more, Peru did not exclude them, even though the treaty's coverage of all forms of public debt, except US to Peru state-to-state loans, got the blessing of Peru's own agency dealing with internal public debt, the GGETP, the very same body within the MEF that was responsible for the land bonds. And as we saw on this timeline, and Mr. Herrera and Dr. Hunskopf confirmed, all of that was unfolding against efforts by these very same Peruvian agencies to come up with an administrative process for finally resolving the land bonds debt, And all of this was unfolding while the Constitutional Tribunal issued several more high-profile decisions reminding the government that it had to clean up its internal public debt that it still hadn't paid, that it had to pay the land bonds at their full current value, and to allow the bondholders to access the courts in order to do that. There is no dispute about those facts. And for those reasons, the hearing confirmed that this treaty covers the land bonds and Gramercy's investment in them. With that, I will turn to Ms. Birkeland to address why Gramercy is indeed the US investor who made that investment.
Thank you, Ms. Popova. Members of the tribunal, I'll be brief because here again, the treaty language is clear. All the treaty requires is that the investor be a US national that made an investment in Peru. And the ordinary meaning of to make is simply to cause something to exist or to give rise to something. And covered investments are ones that an investor owns or controls directly or indirectly. GPH and GFM clearly meet this test. They are both indisputably US companies. There is no serious dispute that they in fact own and control the bonds, and they undoubtedly made an investment when they developed a strategy to resolve Peru's agrarian reform debt and bought millions of dollars worth of bonds as part of that strategy. Either ownership or control is enough. The treaty requires nothing more. It doesn't require an active contribution or some alternative test of a contribution of one's own or some other misreading of the treaty. Although Gramercy would, of course, meet all of those tests if they did apply. Ambassador Allgaier confirmed this, and he wasn't crossed on it. And in its post-hearing brief, all Peru can muster is to continue to rely on cases that we've already said are inopposite, and one of which has in fact been annulled, precisely because it misread the treaty in the way Peru urges. Let's consider each claimant in turn. First, GPH. The hearing testimony confirmed that GPH owns the bonds. Professor Boulard and Peru's expert Dr. Hunskopf agreed that GPH validly acquired title to the bonds as a matter of Peruvian law. And Mr. Königsberger testified that GPH has owned the bonds since day one and has done so continuously ever since. As Mr. Lanava explained, GPH financed the bond purchases through its own capitalization. Gramercy's clients subscribed to equity in funds with interests in GPH, and those funds were equitized through capital contributions to GPH. After capitalization, GPH had a running balance, which it used to buy the bonds. There's nothing unusual about any of that. I was just muted by the host. That background noise was not on my end, I'm sorry.
No worry at all.
Yeah.
The second baby during this hearing, maybe.
Yeah, none of them are mine. Not so far anyway. We'll hope it continues that way. All right, so that was GPH. Let's turn to GFM now. The hearing testimony confirmed that GFM controls the bonds through its control of GPH. Mr. Königsberger and Mr. Lanava testified about how GFM makes investment decisions about the bonds, about their monetization and distributions. Consistent with GPH's operating agreement, any monetization of the bonds will flow exclusively to GPH, and GFM exclusively decides whether and when to make distributions to upstream stakeholders. Those distributions are not automatic. As Mr. Königsberger testified, and I'll quote him, "Gramercy is the only entity that owns and controls." He continued, "So it's Gramercy through the investment manager GFM that is the only one that can make all the decisions relative to the bonds. And it's a Gramercy vehicle, and by that, of course, he meant GPH, that owns the bonds and has title. And therefore, it's the only owner and the only one that can make ownership decisions." So not only did the testimony confirm that Gramercy owns and controls the bonds, but also that it is the only one who owns and controls them. With that, I turn the floor back to Ms. Popova. Thank you.
Thank you very much, Ms. Popova.
Thank you, Mr. President. Now, I want to open a parenthesis here to briefly mention denial of benefits. For the very first time in Peru's post-hearing brief on jurisdiction, Peru sought to deny the benefits of the treaty to Gramercy under Article 10.12. Now, we address this at paragraphs 47 to 49 of our post-hearing brief. In sum, this objection is simply precluded under both the UNCTAD rules and your procedural order number 1. And as a result, you cannot consider it because Gramercy has not been afforded an opportunity to respond to it or to lead any evidence to rebut it. And that's no doubt the reason why Peru only raised it now. It's because it knows that this argument is meritless. Because Gramercy's nationality, its US nationality, is not one of convenience. Gramercy is based in Connecticut. It does all of its business there. And as Mr. Nalaba told you, its beneficial owners are overwhelmingly millions of US pensioners. So we don't know what Peru will say about this tomorrow, but it's never denied that it's procedurally improper to bring a threshold jurisdictional admissibility objection 2 years after the deadline in the UNCTAD rules and 5 months after the end of the evidentiary hearing. Instead, adding insult to injury, Peru claimed that we shouldn't even be allowed to tell you that their objection is precluded and meritless, and they seek to strike our response and the associated authorities about that. Now, you have the parties' letters about this, and all I will say here is that Peru's remarkable approach is really symptomatic of the lengths to which it has to go to avoid the fact that Gramercy is an investor that made an investment, and both are protected by the treaty. So that leaves Peru's kitchen sink objections about consent and abuse of process. Now, I will deal with waiver and timeliness of claims together because they're really relevant together. First, Peru has conceded, finally, that it has no time bar or waiver objection with respect to GFM. So if you agree that GFM is a covered investor with a covered investment, then Peru's waiver and time bar objections become completely irrelevant because they have no effect on any of the issues that you need to decide. Second, Peru's residual time bar objection to just GPH's claims depends on when GPH's claims are deemed to have been submitted to arbitration for purposes of the 3-year time bar in Article 1018.1. And the answer to that question is June 2nd, 2016, for the reasons that we explained in our briefs. And there are 2 independent analyses that lead to the same outcome on this question. First, a qualified waiver is perfectly consistent with the treaty. And second, even if it weren't, an imperfect waiver is still enough to stop the clock on the time bar. And either one of these approaches means that all of GPH's claims are timely. Now, Peru has no answer to either of those arguments. Again, it has objected to putting into the record a decision from just months ago on this very question under this very treaty against Peru itself and even argued by the same council. And again, that just goes to show that their only defense strategy is not to address the substance of the issues, but to dodge them and try to prevent you from considering them. And third, even if you reject both of these analyses and nevertheless conclude that the June 2nd submission of claims did not stop the clock, Peru's time bar objection still fails because it doesn't actually affect any of GPH's claims. Now, again, Peru hasn't actually done the claim by claim analysis that Article 10.18.1 of the treaty requires. Instead, it claims that GPH knew or should have known that both a breach had occurred and that it had suffered loss from that breach by no later than the 16th of July 2013 with respect to all of its claims. But that's not actually true with respect to any of GPH's claims. And you can see that on the next timeline. Now, in July 2013, GPH didn't know about the August 13 Constitutional Tribunal resolution. It didn't know that this resolution foreclosed access to the courts that had existed for decades and which the Constitutional Tribunal itself had protected in its 2004 decision. It didn't know about the January 2014 Supreme decrees, issued 6 months later, or for that matter, the February and August 2017 decrees about 4 years later. It didn't know about the arbitrary formulas in those decrees. It didn't know that the process they created would be Byzantine and confiscatory. It didn't know that they would put Gramercy, and Gramercy alone, last in the line for payment. And it didn't know that the MEF, in issuing those decrees, defied its own basic rules of legality and reasonableness, facts that were only discovered in the course of this arbitration. And it didn't know that the July CT order itself had been doctored to turn the majority opinion into a dissent with whiteout and based on false pretenses, a fact that Gramercy didn't learn until the scandal broke in 2015. And it didn't know about the MEF's 11th hour interference with that decision, or the testimony of the CT justices themselves years later in an investigation that continues to this day. Now, again, there is no dispute about any of those facts, and they mean that none of GPH's claims are time-barred. As the recent decisions in mobile and resolute forest products confirm, which Peru does not address, knowledge of breach for an expropriation cannot possibly occur until there has actually been a substantial deprivation of value. It's an integral element of the breach itself. And here there was no such deprivation until the MEF issued its supreme decrees with their value-destroying formulas at the earliest. And GPH's other claims, minimum standard of treatment, national treatment, most favored nation, all arise out of conduct that occurred or was discovered only later. Now, that's the right analysis as a legal matter. And at the hearing, Mr. Königsberger's evidence about what he and other Gramercy executives actually understood and believed at the time resoundingly confirmed that analysis. And so too does the documentary record, which we again address in our briefs and which again Peru ignores. For example, Mr. Königsberger testified that Gramercy only appreciated that something had gone awry sometime after analyzing the formulas in the January decrees. Now, sure, when the July 16, 2013 order was issued, Gramercy was surprised, as Mr. Königsberger explained. So was everyone else. Gramercy, like everyone else, expected the CT order to confirm the 2001 decision. Now, it understood that what the CT had ordered in July 2013 was something different. It understood it might have an adverse impact on its investment, but the extent of that impact wouldn't become clear until months later. The order itself said that the MEF had to implement it within 6 months. And for that reason, as Mr. Königsberger explained, of course, without waiving legal privilege, he believed it would have been premature to commence arbitration at that point. In fact, 2 years later, in 2015, the CT itself said that a bondholder challenge to the order was premature because the MEF had not yet implemented the relevant decrees. And moreover, until the later resolutions, Gramercy believed it could still get relief from the national courts. So, in fact, it's rather indicative of Gramercy's worldview that Mr. Königsberger believed that the CT order actually created what he called in his December 2013 letter, a historic opportunity for the MEF to actually put in place the kind of global resolution that Gramercy had been urging for years. And consider also Peru's own conduct. We've not heard a peep about that, but the hearing exposed that not even Peru apparently had the crystal ball that it says Gramercy had on the 16th of July in 2013. Peru itself issued 5 different formulas, purportedly implementing one and the same decision, formulas that Professor Edwards showed you could be interpreted about a dozen different ways. Even the 2 highest ranking members of the MEF didn't understand those formulas, couldn't explain to you how they related to the CT order. Even Peru's economic experts who Peru hired, presumably to defend those formulas, told you they were nonsense. And even the Supreme Court had a different view from the MEF about what the CT order actually mandated. Because as you know, the Supreme Court repeatedly awarded compensatory interest at the coupon rates, even after the CT order decision. And we know that that interest is a highly valuable component of these 40-year-old bonds. And when I crossed Dr. Hunskopf about those decisions, he readily agreed they were perfectly consistent. He said there'd been a forum, they were just an example, and that all of the decisions went that way. So not only were the consequences of the CT order patently unclear from its face, but the way in which the MEF later implemented that order was itself unpredictable, arbitrary, and irrational. And that is something that cannot be something that Gramercy knew or should have known standing months and years earlier. So as a result, Peru's waiver and time bar objections with respect to GPH are both pointless and meritless. Now, this leaves Peru's argument of last resort, bad faith. In its post-hearing brief, this has been promoted to Peru's first argument under the cloak of abuse of process. Mr. Königsberger's evidence was the nail in the coffin for that theory. Let's come back to basics for a moment. Peru's attempts to dilute the high threshold that it must meet to succeed on this argument cannot work. It remains one of bad faith. That is the underlying doctrinal, conceptual justification for this clause échappatoire, this theory that would disqualify Gramercy from exercising rights it undoubtedly has, and which the state parties in this treaty nowhere contemplated as a defense in the express text. And bad faith is and must be an exceedingly high and fact-based standard. Peru surely would agree it's very, very rarely applied. And in its briefs, it relies on the Phoenix Action decision, with which, of course, Professor Stern will be quite familiar, and which found it was abusive to internally reorganize the claimant after the breaches had already occurred and after the damage had already occurred, and only for the purpose of bringing litigation rather than any legitimate economic reason. And even Professor Reithman said that in his view, there must be a high threshold of near certainty that there was a reorganization for the purpose of benefiting from treaty protection. Now, his opinion on whether or not the partial facts that he was instructed by Peru to assume meet that standard is really neither here nor there. But however you look at it, none of the various articulations of abusive process can possibly be met on the facts of this case. There is no evidence on the record that Gramercy invested in Peru in 2006 so as to bring a treaty arbitration 10 years later, arising out of events that only occurred 7 years later. Peru does not even try to show you that its breaches were remotely foreseeable, let alone near certain, back in 2006 and 2008 when Gramercy invested. And Peru has not even attempted to establish that Gramercy invested in Peru and spent months finding bonds and paid $33 million for them because it saw all of those things coming. And it thought, gee, I'd better add a US investor into the mix. Peru does none of that. Instead, Peru now claims in its post-hearing brief that Gramercy was, quote, a third-party funder, it says, for a dispute that had already arisen, and it cites a 2006 email that contains the word claims. Mr. Königsberger told you that just means the bonds themselves, claims to payment of current value under Peruvian law. Now that's obvious from the document itself if you read it, as well as from all of the other documents, again discussed in our briefs. And Mr. Königsberger, in fact, strongly rejected the notion that there was any uncertainty or dispute affecting the entitlement under the bonds at the time that Gramercy invested. There was no question that Peru was bound to pay them. No doubt, as Dr. Hunskopf put it when he was pressed to retract his gamble comment. So Peru's argument seems merely to be that Peru hadn't yet paid the bonds in 2006 when Gramercy invested. And that's both obvious and irrelevant. Peru's abuse of process argument is really derivative of its misguided defense on the merits, that the bonds' value was uncertain, that Gramercy's investment was therefore speculative, and that that is somehow the reason why Gramercy's claims are now abusive. And Peru continues to ignore the extensive evidence of the real reasons why Gramercy invested, which Mr. Königsberger has explained at length and on which, again, he was not meaningfully crossed. Peru did not put a dent in his testimony that Gramercy invested because it saw an opportunity to resolve the land bonds debt in a consensual and mutually beneficial way. It didn't cross him on why he believed that a reverse inquiry credit swap would be beneficial for Peru. It didn't meaningfully cross him on his belief that the time was right to do that for Peru, about how he'd watched Peru's success story and he'd seen how Peru had restructured its Paris Club obligations and the Brady bond debt, or about how the 2001 and 2004 Constitutional Tribunal decisions meant that this was the time for Peru to finally clean up this land bonds debt, except really to try to challenge the accuracy of Gramercy's due diligence memorandum, which, as you'll remember, fell apart when it became clear that Peru was itself confused about the dates of those decisions. And it did not cross Mr. Königsberger on the wealth of contemporaneous documents proving how Gramercy actually put that strategy into practice over the long term. That is what Gramercy told its investors back in 2008. That's what it proposed to the Peruvian government in May and June 2009, and again in December 2013, and again in April 2014, and as late as September 2017 after the 2014 Supreme decrees. Peru's abuse of process claim cannot succeed because it requires you to find that all of these contemporaneous proposals to Peru were disingenuous. It requires you to find that Gramercy misled its investors about what its investment strategy was for the better part of a decade. And it requires you to find that Mr. Königsberger was lying on the stand. That he was lying not just about what Gramercy's strategy was when he decided to invest in Peru in 2006, not just about the efforts that Gramercy deployed over the 14 years since then, but also when he said that a consensual resolution to the land bonds debt remains Gramercy's hope even today. Mr. Königsberger still extends his hand to Peru. He still hopes that Peru will do the right thing for all bondholders. Regrettably, it may now take your award to make that happen. Thank you for your attention. I will now return the floor to Mr. Friedman to briefly conclude.
In concluding, I wish only to make the briefest remarks, but to amplify some of the themes that Ms. Popova was just developing and address head-on the underlying motif of Peru's entire case, namely that Gramercy, this investor, is nothing more than a rapacious hedge fund speculator, a vulture, and consequently deserves neither your sympathy nor an award in its favor. But that kind of base, prejudicial demagoguery could not be more wrong or hypocritical. In principle, there is absolutely nothing wrong, dirty, immoral, illegal, or otherwise disabling about the fact that Gramercy is an asset manager and that it invests seeking profits. All investors do. It's how states attract foreign capital and why they sign investment treaties in the first place. And our treaty even has a whole section encouraging trade and investment by US financial services firms. So trying to demonize Gramercy because it is in the business of investing for profit gets Peru nowhere. But more importantly even than that, this whole vulture narrative could not be more inapt given the facts of this particular case and this particular asset manager. The labels imply trying to take unfair advantage of another's misfortune. But that is not remotely what Gramercy did. As Ms. Popova just described, that Gramercy had a completely different motive. Now, it's true that Gramercy bought bonds at a discount to their intrinsic value from bondholders who had received nothing for decades. But Gramercy was always upfront with them, and you even had evidence from one of them who explained that she was satisfied with what Gramercy had done, considered they were honest, and put the money to good productive use. The sellers agreed to sell to Gramercy because Gramercy paid them fairly tens of millions of dollars when the government had done nothing but rebuff them for decades. And then Gramercy sought, with the most amicable and consensual solution, with the stated goals that they wanted to help create a solution that benefited everyone, all the bondholders equally, not just Gramercy. and even Peru itself, at a time when that kind of validation could have sped its economic recovery. This is not the conduct of a vulture. In contrast, who can defend the conduct of the Peruvian government in this whole long affair? It was the government that confiscated land the size of Portugal and did not pay for it. It was the government that drove the economy into the ground and initially undercut the value of the debt. It was the government that refused to make good on the debt, even after the Constitutional Tribunal held that it had to be paid at current value. It was the government that manipulated the Constitutional Tribunal, ignored its own laws, and created a bondholder process with arbitrary and irrational payment formulas. It is the government that is paying Mr. S and Miss L and other bondholders just like them absolutely trivial amounts of money of which the society should be ashamed. And it is the government that says even today that it owes Gramercy nothing on its nearly 10,000 land bonds. The government is just trying to at long last get away with and get your vindication of what must be one of the largest uncompensated expropriations in history. Fortunately, international law protects against that kind of manifest injustice. And under our treaty, it will now be in your hands to apply that law. For obvious reasons, Gramercy is the only bondholder that is a party to this arbitration and the only party for whom you can order relief. But the decision you make here will undoubtedly have reverberations in Peru and be looked to by all bondholders seeking at last some kind of justice. And so it should be, for that is precisely the kind of righting the balance pursuant to international principles that international investment law should always aspire to achieve. With that, Mr. President, members of the Tribunal, we conclude our submissions for today, and thank you for your careful attention.
Thank you, Mr. Friedman. Let me get a time check from the Secretary first.
Thank you, Mr. President. The claimants have used 2 hours and 33 minutes.
So perfectly within time. Thank you for adhering to the time slot. Let me now see if my esteemed colleagues have some question. And shall I turn first? I see Mr. Dreimer making himself ready to put some question, or to say that he has no question.
It was rather the latter. I just wanted to be sure that my microphone was on. No, nothing for the moment. Thank you.
Professor Stern.
I have a few questions, but yes, I have a few questions on what we heard today. But before of that, I would like to clear up my mind on our two claimants. In the claimant third amendment and statement of claim in paragraph 28 and 29, it is stated that JFM is a limited liability company organized under the law of the states of Delaware, United States. And 29, GPH is a limited liability company organized under the law of the state of Delaware, United States. Now, I have been trying to understand, because it's a little complicated, document C703, which is Peru structure charts of Gramercy.
Thank you, Mr. Friedman. I give back the floor to Professor Stern.
Thank you. So my first question is to you, Mark Cantor. We know that Gramercy bought the land bonds between 2006 and 2008. I mean, the one which we are concerned here. And in your presentation, you said that CPA was a general rule before 2013, as well as the payment of interest. And I cite you say there was no uncertainty at the time, none at least if you went to court, the current value of the land bond and It did so in many, many, many cases overwhelming. And then you added, there was also no uncertainty about interest, at least at the stated coupon rates, none. And what you complain about is precisely not to have received a value based on CPI and interest. But why didn't you go to court before 2013? Because you say yourself in slide 43 of your statement that in the Peruvian court you would have obtained for 841 million, which is what you ask alternatively in your statement of reply. In the alternative of the 1.8 billion, you ask 842 million. So why didn't you go to the courts?
Gramercy did go to the courts. So let me just
for a few for 44 bonds.
44 bonds that represented a quart, but there were 44 by number, but by value, they represented more than 25% of the value of Gramercy's portfolio. I think to fully answer that question, I think you would credit and take seriously Mr. Königsberger's testimony that the whole idea of Gramercy investing was not simply to let's buy low, then run off to court and enforce our legal rights. Instead, the idea was let's invest and let's build this virtual circle whereby we create a global solution for everybody that will enhance the creditworthiness of the country, bring in the other bondholders, and that will be a more durable solution than just trying to pick off our bonds and going to court. And that's what they diligently pursued for several years. But there was the financial crisis in 2008, in which people were focused on other things, and I think Gramercy was clear about that. So it wasn't thinking about this investment especially hard in the period of 2008 to 2009. But then when other efforts at trying to create that global solution weren't gaining the traction, they came very close on a couple of occasions, but then got vetoed by the executive and died at the last ditch. And at that point in 2011, Gramercy submitted those conciliation requests to the Peruvian Ministry of Economy and Finance. Now, those conciliation requests, you will recall, are all those documents that Mr. Hamilton brought to the hearing last time and said that Gramercy was hiding all of the bonds. In fact, it provided all of those documents, copies of all of the bonds and all of the acquisition documents to the Peruvian government in 2011 as part of this conciliation process. The conciliation process is a necessary prior step to being able to assert litigation over the bonds, but it put 100% of the bonds into the conciliation process. Conciliation was obviously rejected by the Peruvian government, and then Gramercy sought to do at least a test case by saying, look, we think we'll get to a global solution eventually, but we'd like to have that, so, but it seems we need to get some attention paid to us. Let us bring a lawsuit and enforce our legal rights in courts, which had never been their primary objective or primary method of trying to realize recovery. And that was the Pamalca case. And so it's not surprising that in that case, and these cases are broken down based on the original land acquisitions. That's why there are 44 bonds in that case. It's because that related to a particular parcel of land for which the government had given those 44 bonds. Those 44 bonds, because of their characteristics, happened to be really good and valuable bonds. They were basically no clip coupons, and they were from an early time, and they had an appropriate interest rate. And so Gramercy said, well, this is a good place for us to litigate. So why don't we litigate over these? They're a very substantial amount by value of our portfolio. And then there was from 2011 to 2013, the Engineers Bar Association in Peru brought the claim at the Constitutional Tribunal. Nobody thought that process would take 2 years. People were optimistic that because of the clarity of the 2001 Constitutional Tribunal decision, that this revived case, it was actually an application in the 2001 case that the engineers brought. And what they were seeking was not a new claim. They were just seeking to have the Constitutional Tribunal issue an enforcement judgment on the 2001 case, because they hadn't done anything in a decade. And it was, I think the entire society and all the bondholders at that point had some considerable hope that the Constitutional Tribunal, which had been, protective of bondholder rights would continue to be, and would issue some kind of binding order that would eliminate the need for everybody to bring their own individual cases in hundreds or thousands of cases in dozens or hundreds of courts all across the country. And so Gramercy chose, yes.
Can I, the secretary is asking me, there is no objection, I would assume, for the United States to come back into the room.
Correct.
Thank you.
So I think that the answer to your question is, if you're asking
I would
about,
suggest we actually wait for the United States government to come back in the room. Peru doesn't agree with their exclusion, but in any event, let's give them a chance to return. And thank you for the observation, Mr. President.
They are back in the room. Thank you.
so
Let us welcome them back. Thank you for your patience. And Mr. Friedman has the floor.
Yes. So Professor Stern, I think that there is, your question is sort of a historical one. Why did Gramercy make certain decisions about litigating at the time that it did and on the bonds that it did, and not about the others in that sequence? And I hope I've provided for you some of the context about which Gramercy, that informed Gramercy's view about how and when to assert those legal rights in Peruvian courts that they always thought that they had. But I think if you look at it, they were patient and tried to pursue their investment hypothesis for a while. When that wasn't moving forward, they did take the step necessary for all of their bonds to be able to revive cases and move them forward in courts. They then did take a quarter of the value of the bonds and pursue it actively, getting favorable opinions from the court-appointed experts in that case that was consistent with the decisions in almost all of the other cases and core principles, while waiting for the Constitutional Tribunal to render its decision, which it ultimately did in July 2013. So I think if the implication of your question was that Gramercy was somehow neglectful or negligent, I don't think that that can be justified on the facts.
I was not saying that you were negligent, but I was, wondering why you did not take this opportunity to go to the court and, in fact, waiting for the law to change and not using the law as it was. But maybe my next question is for Mr. Carl Riel. I don't see him. Does he hear me? Does he? Yes.
Yes, here I am.
Yeah, okay, now I see you. You spoke a lot about the intrinsic value of the bonds. I would like to understand in which world you find this intrinsic value. First, the 1.8 billion, then the 840,000 million. How do you reconcile, these figures in particular? How do you reconcile these figures with what Mr. Königsberger stated in his second amended witness statement in paragraph 21, which is the face value of the land bonds as denominated in soles de oro was worthless even in 2005?
Yes, thank you, Professor Stern. The operative phrase there is the face value, right? So that was a reference to the face value or the nominal value, which is explicitly the value that the Constitutional Tribunal in 2001, explicitly said would be a constitutional violation to pay that value.
Okay, and how do you reconcile these figures with what you paid for the bonds? The intrinsic value.
Yes, Professor Edwards has given testimony about that, and there's other evidence in the record. At the time of purchase, there was considerable uncertainty as to whether Peru would pay the bonds fully and would pay their full value, and there was considerable uncertainty about the timing of that value. Professor Edwards gave testimony that as the uncertainty diminishes, that value reduced for the risk of payment that was not full or prompt would converge to the intrinsic value. And you may recall as well, there was an exhibit in Professor Edwards' presentation at the hearing showing how that intrinsic value has increased over time. So even to the extent that you want to hold up the intrinsic value in comparison to the value at some other prior point in time, $841 million was in 2018, which is a decade or more later, and the intrinsic value had grown during that time.
And the 1.8 billion, where does that come from?
That also includes compensatory interest is a substantial part of that. The difference between the 1.8 and the 841 million is entirely a result of what interest rate is applied. So the 1.8 billion uses the 7.22%, which is based on the actual historical rate of return Peruvians have actually achieved. Everyone who had money in their pocket in Peru to invest was able to invest it and receive that rate or more. Whereas the bondholders obviously didn't have the money, and that interest continued to accumulate. The 841 million is calculated using the lower original coupon rates.
Okay, well, thank you for the clarification. Well, maybe I have also a question or two for Ms. Ina Popova. Okay. Yes. You were dealing with the definition of investment. And you said, well, if you ask in the street, whether it's Wall Street or an ordinary street, you will have an answer. Well, I am a little surprised by such a comment from a sophisticated lawyer. And also, I am not sure that you read completely the definition, because you said investment means every asset, and that as there is a reference to all assets, well, it was every and all, it means that that means that there are no characteristics of investments, but you didn't read the rest, including such characteristics. So I just couldn't follow you.
So we've never disputed that an asset must have the characteristics of an investment in order to be covered by the treaty. I don't think there's any dispute between the parties about that. I think what is undisputed, though, and it's also clear from the text of the treaty, is that those characteristics that are identified in the treaty are not mandatory and they are not cumulative. And the other thing that's clear, and on which all of the experts and Mr. Herrera also agreed, is that the list of forms that an investment may take are the kinds of assets that the state parties contemplated would in fact have the characteristics of an investment. And at the end of the day, if we go back to the interpretation of the treaty, we must begin with the ordinary meaning of its terms read in good faith and in context.
Well, I mean, if they say including such characteristic, it does not necessarily mean that they do all include it. And I mean, I think you have read, as I did, note 12, which means that some might be an investment and some might not be. So I think you were a little bit quick on that definition. But let's go.
Sorry, footnote 12 says that some forms of debt are more likely to be investments, and it specifically calls out bonds.
Yeah. Okay, but if they have the characteristic, which means that not all of them have it. Okay.
Absolutely, but in this case, the bonds had all of the ones that are listed and more.
Okay, and at one point you mentioned quite rightly that in Annex 10F, it is stated that a public debt entails commercial risk. This is absolutely correct. This citation is correct, contrary to the other one. And I wonder whether you assimilate a commercial risk with an investment risk, which can be called an operational risk. For me, a commercial risk is a risk inherent in the fact that one of the parties might default on its obligation. But you know that an operational risk is a risk coming from an an economic operation whose result is unknown. So do you make a difference between commercial risk and investment risk, as some, you know, cases do, which you probably know?
I think in this case, Professor Stern, there is no difference because there is, however you want to define the risk, it existed here. And if you take the view that a financial investment like a debt or let's take even a share ownership in a company or futures, options, derivatives, other debt instruments that this treaty protects, if you take the view that they don't carry risk, then they would never be protected under this kind of treaty. And we know that that can't be true.
But the value of a share depends on the results and the profits made by the company, which is very different.
But the shareholder is not necessarily the one that drives that performance. And here, Gramercy did invest not just to passively hold debt instruments, but actually to realize the real value, the inherent value of not just its own instruments, but also those of all of the other bondholders in Peru. And we have unchallenged testimony about that.
But could you give me a definition of the investment operation in which Gramercy entered to
Absolutely.
create value?
I think Mr. Königsberger has given us several definitions that are probably much better than the ones I can give here. But what Gramercy invested in is the hope and the expectation that it would be able to help Peru resolve its stagnant land bonds debt. And that in doing so, it would not only achieve the current value of the debt instruments that it itself held, but also that it would achieve the benefits that it had seen that it could achieve for other countries over time. And I don't think that there's the requirement of sort of some particular qualification of the risk, of the kind of risk that is required for an asset to qualify as an investment. I'm not sure that calling it operational or defining that in any particular way is particularly helpful, frankly. And again, as I say on the facts of this case, those kinds of distinctions don't help us.
Okay, life is a risk inherently, okay. So I think I have finished my questions.
Thank you. Thank you, Professor Stern. I do have some questions, but I think we have for tomorrow, after the presentation by respondent, we have scheduled some time, and I would rather hear the position of respondent, and then maybe we can have, it is more meaningful to have the questions then. So I will postpone them for tomorrow. So assuming that there is no further business for the day, Mr. Hamilton?
Mr. President, thank you very much for the attention of the tribunal. Just a brief note for the record that the Republic of Peru reiterates its objection to references to materials that are not in the record and have not been addressed by the Republic of Peru, nor by the non-disputing party, the United States government, which is also pertinent. We also reiterate our objection to the exclusion of the United States government from any of the components of this proceeding. And we also maintain an objection related to the characterization of the presentation of Gramercy documents that were held or withheld over time, and we will address that in due course. Simply note that for the record, and otherwise, I look forward to everyone having a night of sleep, being able to emerge like emerging from the wardrobe, leaving the fantastical world of Narnia and coming back to reality. And we will address many issues tomorrow. Thank you for your attention.
Thank you, Mr. Hamilton. Mr. Friedman, do you have any comments?
No, thank you. We just once again to express our thanks to the tribunal.
Very good. So we will be meeting tomorrow at the same time as today. I thank the interpreters and the court reporters. It must have been a difficult day for them because there was quite some substantial presentations. And but now we have all some time to rest and come fresh again tomorrow. So thank you very much to all of you, and we meet tomorrow.
Thank you.
Thank you very much.
Thank you.
Goodbye.
Thank you, Mr. President.
Thank you very much.
Do we go to our room? No?